Good afternoon, everyone. This is case number 9490, the evidentiary hearings in Potomac Edison's rate case. And I believe do we have any preliminary matters this afternoon?
Yes, very briefly, Your Honor. Yesterday, the commissioners had three bench data requests. I can report to you now that with respect to Commissioner O'Donnell's request, the information that he's seeking is in fact in a document which will come into evidence when Mr. Valdez's testimony is admitted. So that will get into the record, hopefully, today. And when Mr. Valdez is on the stand, he'll be happy to direct folks' attention to the specific place where it is. And Commissioner Herman, with respect to your two data requests, I am advised, work has begun on assembling all the information you requested, and I am advised that we should have complete answers for you in written form Monday, and so we'll be able to offer them into the record at that time.
Okay, thank you very much. Any other preliminary matters? All right, Mr. Trout, I'm going to call you next witness.
Thank you, Your Honor. The company calls Laura O'Black.
I do.
Good afternoon, Ms. O'Black.
Good afternoon.
Could you please state your full name for the record and spell your last name?
Laura O'Black, O-B-L-A-C-K.
What's your business address?
800 Cabin Hill Drive, Greensburg, PA.
For whom do you work, and what's your job title?
I work for FE Service Company, and my title is Regulatory State Analyst.
How long have you worked for First Energy or for Allegheny Energy? 40
years.
And during those 40 years, how many times previously have you actually testified in a hearing like this?
None. This is my first.
Okay. Well, we're delighted to have you.
Do you have in front of you three documents? Hopefully you do.
I do. I do.
Okay. Is the first one, consisting of 16 pages of testimony and 9 exhibits, entitled The Direct Testimony of Laura M. O'Black?
Yes, I do.
Okay. Your Honor, could we please mark Ms. O'Black's direct as Applicant's Exhibit 20?
So marked.
Is the second document, consisting of 3 pages of testimony and another 9 exhibits, entitled The Supplemental Direct Testimony of Laura M. O'Black?
Yes, I do.
And finally, do you have a third document consisting of 15 pages of testimony and 4 exhibits entitled The Rebuttal Testimony of Laura M. O'Black?
Yes, I do.
Your Honor, I would ask that we mark the supplemental direct as Exhibit 21, Applicant's 21, and the rebuttal as Applicant's Exhibit 22.
So marked.
Ms. O'Black, did you prepare this testimony, or was it prepared under your direction and control?
Yes, it was.
If I asked you these same questions today, would you give the same answers as are written in the testimony?
Yes, I would.
Do you adopt these 3 documents as your testimony in this proceeding?
I do.
Your Honor, I would offer into evidence, subject to cross-examination, applicants 20, 21, and 22.
They are admitted. Seeing no objection.
Okay. And the witness is available for cross-examination.
Mr. Cleaver?
Thank you, Your Honor. Good afternoon, Ms. O'Black. My name is Joe Cleaver. I'm from the Maryland Office of People's Counsel. I'm going to start off with some pretty basic questions, but just for some background.
Okay.
So, PE has distribution operations in Maryland and West Virginia. Is that correct?
That is correct.
And so, in order to quantify the rate base and revenues and expenses for each of those two jurisdictions, the company has performed a jurisdictional separation study, correct?
That's correct.
And the first step of that study is to functionalize system costs per the FERC uniform system of accounts. Is that correct?
That's correct.
Okay. And one category of utility costs is general plant. Is that right?
That is true.
And NARUC defines general plant as, quote, that portion of the plant that are not included in production, transmission, or distribution accounts, but which are nonetheless necessary to provide service. Do you agree with that definition?
Yes, I do.
Okay. Now, general plant costs are recorded in accounts 389 to 399 under the FERC Uniform System of Accounts, correct?
That is correct.
Okay. And account 389 primarily relates to the land in which service centers are located.
True.
And account 390 primarily relates to the service centers themselves, correct?
Correct.
Okay. Now, PE, for purposes of assigning accounts 389 and 390, undertakes a two-step process, correct?
Yes, that is what we did.
And the first step in your jurisdictional separation study was what we're talking about, correct?
I agree.
Yes. And the first step, those two accounts are directly assigned to Maryland, correct?
Yes, that is what we did.
And then in the second step, you allocate them to the Maryland distribution system as labor-related using the ratio of total company distribution salaries and wages to total company salaries and wages. Is that right?
Yes.
Okay. Now that's the second step of that process that I just described, the labor ratios part of it. The purpose of that is to separate distribution from transmission, correct?
Correct.
Okay. Now, for the remaining general plant accounts, which are 391 to 399, the company does not directly assign those to Maryland as part of step one, correct?
That is true.
And how, could you state for the record and explain to us, how are those remaining general plant accounts, 391 to 399, assigned in the jurisdictional separation study?
We take the total, for Potomac Edison, and at that point we allocate the costs on transmission and distribution plant. And at that point, once we're in the Maryland, once we've determined what is Maryland, we then allocate on salaries and wages to get it to the distribution piece.
Thank you. And those accounts represent things like furniture, is that right?
True.
Equipment of the company? Tools?
Correct. Mm-hmm.
Is that correct? The tools
Yes, that is correct.
Thank you. And are any of those items, the furniture, the equipment, tools, any other tangible items in those accounts, is any of that stuff physically located at any of the service center sites that are included in count 390?
Those items are physically located, but they can be moved from one location to another.
As we sit here right now at this time, there are certain items that are tangible items in those accounts 391 to 399 that are presently physically located in the service centers that are in account 390. Is that right?
Oh, yes, that would be true.
Okay. And is it also fair to say that some of those tangible items in accounts 391 to 399, even if not physically located inside of a service center, may be located on the land that houses the service center that's included in account 389. Is that right?
I'm sorry, could you repeat it?
Sure. You would agree that some of that tangible plant, general plant included in accounts 391 to 99 is physically located at present, some of it, in the service centers that are in account 390, correct?
Yes.
Okay. And is there also some portion of that tangible plant from accounts 391 to 399 that, while it may not be inside of an actual service center, is on the land that houses the service center that's included in account 389. Equipment.
Okay, so
tools.
for example, I was going to say equipment. Yeah, I would agree with that.
Okay, thank you. Now, with respect to the first part of the assignment of accounts 389 and 390, which is a direct assignment to Maryland, as we talked about, you're aware that OPC witness Dr. Pavlovic disagrees with the direct assignment of those counts to Maryland.
I do agree that was in his testimony.
Yes. And Dr. Pavlovic's position, and with the understanding that you disagree with it, but do you understand Dr. Pavlovic's position to be that general and intangible plant comprise precisely those facilities and costs that are not directly assignable to any specific sub-function of a utilities operation and thus are to be classified as common? Do you understand his testimony to say that?
I'm sorry, could you repeat that one more time?
Sure. Do you understand Dr. Pavlovic's position to be that general and intangible plant comprise those facilities and costs that are not directly assignable to any specific sub-function of a utilities operation and thus are to be classified as common? Do you understand his testimony to say that?
Yes, I do understand that.
Okay. And in your rebuttal testimony, you explain your disagreement with Dr. Pavlovic's opinion in that regard, correct?
Yes.
Okay. If I could ask you to turn to page 3 of your rebuttal testimony. And specifically, I'm looking at the question that starts on line 17 and then continues on to page 4. The answer is on page 4 and continues through line 6. Could you read that question and answer and let me know when you've had a chance to read it?
Wait. I'm sorry, you said starting on page 4 line...
I'm sorry, page 3, line 17 to page 4, line 6 of your rebuttal testimony.
Okay. Okay, I've read it.
Okay. And in explaining your disagreement with Dr. Pavlovic's position on this point, as reflected in this question and answer, you cite the NARUC manual at page 105. You cite the NARUC manual statement that another suggested basis is the use of operating labor ratios.
That's true.
Do you see that?
Mm-hmm.
And that's at page 105. In his direct testimony, doesn't Dr. Pavlovic acknowledge that labor ratios can be used to allocate common plant and that that's appropriate?
I can't recall that specifically, but subject to check, I would...
All right. I have a copy of his testimony if you'd like to see it.
I can...
Sure.
Okay.
May I approach the witness, Your Honor?
Yes.
With a copy of it.
Is there a specific page you'd like to draw her attention to?
I'll get that. Ms. O'Black, the provision in Dr. Pavlovic's testimony is on page 10. And what I've handed you is a copy of his revised direct testimony filed on December 6th. If you look at page 10, line 17.
Okay, I've read that.
Okay. So, would you agree that it's not Dr. Pavlovic's testimony that a labor ratio is improper for allocating common plant, but rather his testimony is that it's improper to first directly assign common plant to a jurisdiction and then apply a labor ratio for purposes of distinguishing distribution from transmission costs?
I do believe that that was the point he was trying to make.
Okay, thank you. If I could turn your attention back to your rebuttal testimony. And specifically, if I could ask you to turn to the first exhibit to your rebuttal testimony, which is LMO 10.
Okay, I'm there.
And this is page 105 of the NARUC manual that we were talking about a moment ago. Is that right?
Yes, it is.
Okay. Now, under this section that says general plant, the second, third, and fourth paragraphs each set forth an acceptable method for assigning general plant, correct?
Correct.
Okay. Now, none of these approaches includes direct assignment to a specific jurisdiction as a first step, correct? As described here in this manual.
As specifically described on this page. I would agree with that comment.
Thank you. If you could turn back to page 4 of your rebuttal testimony at line 7. And if you could take a look at the Q&A that starts on line 7 and continues to line 14.
Yes, I'm familiar with this.
Okay. And the question asks why you believe plant accounts 389 and 390 should have a direct allocation. And you state, first, general plant FERC 390 structures and improvements primarily relates to service centers. Because service centers house operations related to their surrounding area and are generally specific to a jurisdiction, it's appropriate to assign these costs directly. You go on to state, second, the purpose and function of the plant booked to general plant FERC 389, land and land rights, primarily relates to the land in which the service centers are located. Therefore, it is appropriate to directly assign these items also. Do you see that?
Yes, I do.
Okay. If I could ask you to take a look at, on the days there, there's two exhibits. And I'd ask you to take a look at the one that's the company's response to OPCDR 29-2. And, Your Honor, I would ask that that be marked as OPC Exhibit 4.
So marked.
Thank you. Ms. O'Black, let me know when you've had a chance to take a look at that response.
I'm generally familiar with this, yes.
You are? Okay. And I note that it was prepared by Mr. McGettigan, who testified, but you are familiar with it?
Yes.
Okay, thank you. This chart that was included as an attachment to the response, it provides details concerning the daily operations of 6 of Potomac's service centers that are physically located in Maryland and 1 that is physically located in West Virginia, correct?
Correct.
Now, these service centers would be included in account 390, correct?
That's correct.
Okay. And is it correct that the 6 that are located in Maryland, as part of that two-step process we described, are directly assigned to Maryland?
Yes, they were.
And was the lone West Virginia site that appears on the back of the chart in Berkeley Springs, was that directly assigned to West Virginia?
Yes, it was.
Okay, thank you. Now, if you could take a look at the very first service center that's listed on this chart, and that's the Cumberland Service Center. And in the substations line, there's 3 lines under daily operations, and if you follow the substations line under jurisdiction, you can see that it states, this group primarily supports Maryland and is also responsible for several distribution substations located in West Virginia. Do you see that?
Yes, I do.
Okay. And now if you turn to the second page of the chart and you look at the Williamsport service center located in Washington County, Maryland, if you look over, you'll see in the substations category, if you go over 2 columns, it says this group primarily supports Maryland and is also responsible for several distribution substations located in West Virginia. Do you see that?
I do.
And then if you go down one row to the next function, controls, and you go over to the jurisdiction column, it explains this group is responsible for distribution operations in all of Potomac Edison, which includes Maryland and West Virginia. Do you see that?
Yes, I do.
Okay, thank you. At the bottom of this chart, there's a note here that says, please note, and this is below the last row. Do you see that?
I do.
Off of the chart. It says, please note, when daily operations require state boundaries to be crossed, costs are allocated according to the cost allocation manual. See that?
I do.
And are you referring to the NARU cost allocation manual there?
I believe, although I did not put this together, we have a manual. We refer to it as the CAM manual, and with our company, it's a means of distributing costs appropriately according to how it was booked in the system.
Okay. Does CAM stand for Cost Allocation Manual?
That is my belief.
And that's an internal document that's internal to PE?
Yes, it is.
Is it specific to Potomac Edison, or is it a First Energy document? Do you know?
I believe it's First Energy related.
Okay. And do you know what that document says regarding how to classify or assign these costs that are incurred when state boundaries are crossed?
My familiarity with the system is there's multiple ways of data being recorded into the system, and based on whether it be a work order or that's one example. It's how the data, the project is assigned in the system, and in how it will be distributed into the system. I can't relate to the specifics as to, from an accounting point, once an expense is booked, how exactly it gets divvied out between, if it does cross state lines. I believe the way the project's set up is that there's a percentage within it that would note to the system how to separate it.
So it would be on a project by project basis. Is that fair to say? Is that your understanding?
I guess what I'm trying to do is just kind of relate to you that the system is set up that when charges are placed into the system, it could be assigned directly to Maryland or assigned directly to West Virginia, or if it's a project that would pertain to both, the system would accommodate that to split the costs.
And how would that, what are the allocation factors used for that split?
I'm sorry, I cannot speak to that.
Okay. Thank you. Is it your understanding that the plant costs that are recorded in the FERC plant function accounts for transmission and distribution, are they allocated pursuant to this company CAM manual when this particular scenario as described in this footnote occurs?
Are you referring to the plant cost, meaning the values that are in the plant accounting system?
Yes.
The plant accounting system is set up that wherever the physical asset resides, that is where it's for transmission and distribution plant. That is where that is the location it is booked in the plant accounting system.
Okay. So if there was a worker or a number of workers from the, say, the Williamsport Service Center that had to, pursuant to their, in this controls group, that had to do some work in West Virginia on some piece of transmission plant in West Virginia, you're saying that would that cost be directly assigned to West Virginia pursuant to the CAM manual if that were to occur?
So I know when work is performed, it can be either capitalized or expensed. As far as the expense portion goes, I'm familiar with just the system in order to, through the CAM manual, to allocate it properly. I can't specifically speak to how the capitalization costs would be booked.
Okay. Thank you. Do you know whether the CAM manual has been produced in Discovery in this case?
I do believe it was.
Okay.
With the supplemental data, but that's subject to check.
Okay. Thank you. You don't buy any. When you say the supplemental data, you mean you think the CAM manual was provided when the company updated its?
I believe it was information that we provided for this case. It was a requirement.
Okay. Okay. Thank you.
Even though I didn't personally provide that.
Thank you. If I could turn your attention to the other exhibit that was left up on the witness stand, and Your Honor, that's the response to the company's response to OPC 24-1 with 2 attachments, and I would ask that that be marked as OPC Exhibit 5.
So marked.
Has 4 been offered into evidence yet?
No.
Has not.
Okay.
Ms. O'Black, let me know when you've had a chance to take a look at that response.
I'm familiar with this response.
Okay. Now, this response provides, the question asks a list of the land tracts included in General Plan Account 389, basis for direct assignment and other details which we'll get to, and then it also asks for a list of structures and improvements included in Account 390, as well as the basis for direct assignment, other things like municipality, gross book value, and that information was provided in these attachments. Is that right?
That's true.
Okay. Now, if I understand this correctly, if looking at Attachment A, this concerns Account 389 land, correct?
It is.
Okay. And there's a key when you look at the column on the let me back up a minute. The first list of locations or land is all land that's physically located in Maryland, correct?
Correct.
And then if you look down to the next list of parcels, it's all land physically located in West Virginia, correct?
Correct.
Okay, and if you look over in the column that says basis of direct assignment, there's a key there, and if I look down at this key and I see F, it says that because communications infrastructure supports its surrounding area and is generally specific to a jurisdiction, it's appropriate to assign these costs directly. You see that?
Yes, I do.
Okay. And it looks, from looking at this, it looks like there are 4 parcels of land in Maryland that are directly assigned because of the rationale set forth in item F in this key, because of the communications infrastructure supporting surrounding area. Is that right?
That's true.
Yes. And then if you look down at the West Virginia parcels, it looks like there's just one North Mountain Microwave that's directly assigned on that basis. Is that right?
True.
Okay. And okay, thank you. And then if I turn the page to attachment B, this is the listing of structures and improvements included in account 390, and again, as with the previous attachment, first there's a list of structures or improvements that are physically located in Maryland, and then there's followed by a list of structures physically located in West Virginia, with one structure from Virginia in the middle, correct?
Correct.
Okay. And that same rationale that was item F in the key on the first attachment is set forth here in item C in this key. Do you see that?
I do.
Regarding communications infrastructure? You see that?
I do.
Thanks. And if you look over at basis of direct assignment, it looks like there's another item that's directly assigned to Maryland on that basis, the Mountaindale Microwave Site in Frederick. Is that right?
Yes, I see that.
But then there aren't any others assigned on that basis to West Virginia in account 390, correct?
Correct.
Okay. Do any of these communications, let me strike that. Do any of these parcels or structures and improvements that are directly assigned to a jurisdiction based upon that rationale regarding communications infrastructure, do any of those play a role in the provision of utility service outside of the jurisdiction to which they're directly assigned?
Yeah. I'll have to admit I'm not 100% certain of that at this point.
Okay. Thank you. Just changing topics, if I could ask you to turn to page 9 of your rebuttal testimony.
I'm there.
Starting up at line 1, you discuss OPC witness Efren and staff witness Valcarengi's recommendation that SERP be removed from the determination of the company's revenue requirement. Is that right?
That's true.
Okay. This testimony was filed on December 20th. Is that right?
Yes.
Okay. Are you aware of the order that issued in this commission's case number 9481, a Washington Gas rate case on December 11th, 2018?
I didn't specifically read that myself, but I do believe I've read that somewhere.
Okay. And are you aware of how the commission ruled on a similar request from Washington Gas to include SERP in its calculation of its revenue requirement?
Could you repeat the question?
Are you aware of how this commission ruled on Washington Gas Light Company's request to include SERP expenses in the calculation of its revenue requirement?
I do believe there was a point where there was a ruling where it was allowed.
Okay. If the commission disallowed the inclusion of SERP in Washington Gas's revenue requirement in an order issued 9 days before you filed your rebuttal testimony, would that change your testimony in this case? On this point?
I would not, just because we believe that these are known and measurable and necessary for key executives in our peer groups. All offer, for the most part, all do offer this also.
Are you aware that a similar rationale to what you just articulated was set forth by Washington Gas's witnesses in case number 9481?
No, I was not.
Thank you, Ms. O'Black. I don't have any... Well, actually, Your Honor, may I have the Commission's indulgence for just a minute?
Yes.
Thank you.
Off the record, right? Are you okay?
Yes.
Ms. O'Black, just returning briefly to a point, something we talked about before, the CAM manual. I think you said you believed it was provided when the case was filed.
I thought it was part of the supplemental information.
So and I'm not trying to... I understand you're not sure, but I just want to... Your understanding is that it wasn't produced in response to discovery, is that right?
That's correct.
But that rather it was produced as a filing from the company?
A filing requirement, I believe.
Okay. All right. Thank you, Ms. O'Black. Your Honor, I don't have any further questions. I would ask that OPC Exhibits 4 and 5 be moved into the evidentiary record.
No objection.
They are moved into the record and admitted. Mr. Spivak.
Thank you, Your Honor. I think we'll start with the exhibits I passed out, and I did realize as I was sitting here that the one person I did not give them to was the witness. So may I approach the witness, please?
Yes.
All right, I just gave the witness a packet. I've already given all of the contents to counsel and to the commission. I'm just going to go through them and authenticate them and try and put them in the record. The first item in the packet I gave you should be the company's response to Staff Exhibit 40.15.
Yes, I have it.
Are you familiar with this response?
Yes, I am.
Okay. I believe actually that this is the complete response to a question for which Mr. Cleaver handed out at the packet yesterday. I think OPC had, the company was planning on entering the whole thing in, and OPC had an objection that they wanted to register. I don't know if they are withdrawing that yet.
Mr. Cleaver, do you have an objection?
Well, I mean, if it's the objection is only that if Mr. Spivak makes a motion to move it into the record, I would just state the same objection as yesterday. This is if Your Honor recalls, I had an excerpt of this. I had asked Mr. Adams about it. I had moved for it. The company had taken the position that the entire spreadsheet, the entire schedule should come in, and I had simply asked to reserve the right to object to that and asked if the commission could hold it until we have an opportunity to see a very limited set of discovery we've propounded on it, the answers of which are due today, and then have a chance to discuss them with Mr. Efron. So if we could just hold it for now. I would say the same thing I said yesterday. This is what Mr. Gunderson had asked should be moved in. What Mr. Spivak just passed up.
Right.
And we're fine with holding it in abeyance, but we would like to mark it as Staff Exhibit 2, please.
We'll hold it, but I'm inclined to admit it into evidence, Mr. Cleaver, unless you have unless you can provide a reason
I
not to. But just we'll hold it and allow you some additional time.
I understand. Thank you, Your Honor.
Now, Ms. O'Black, you did say you were familiar with this item,
Yes.
and is the information contained in it, to the best of your information, knowledge, and belief, true and complete?
Yes, it is.
Okay. As I said, I'd request that be marked as Staff Exhibit 2, please.
So marked.
Okay. Do you have next document here, which is the company's response to Staff Data Request 32.10?
Yes, I have it in front of me.
Okay, and did you prepare this response, or was it prepared under your direct supervision?
It was under my direct supervision.
Okay. And is the information it contains true and complete to the best of your knowledge?
Yes, it is.
Your Honor, staff requests that that be marked as Staff Exhibit 3, please.
So marked.
Okay. Okay. Do you have there's a company's response to Staff 31.9?
Yes, I do.
And did you prepare this response?
It was prepared under my supervision.
Okay.
Just a minute, Mr. Spivak. I'm looking for 31.9.
Yeah, we don't have that either.
I don't have 31.9, Mr. Spivak.
All right. All right, and you said this was prepared under your supervision?
Yes, it was.
Okay. And is the information it contains true to the best of your knowledge and belief?
Yes, it is.
Okay. We'd like to mark this as Staff Exhibit 4, please.
So marked.
Do you have in front of you the company's response to Staff Data Request 32.7?
Yes, I do.
And was this response prepared by you or under your direct supervision?
Under my
Spivak.
direct...
You're missing this one, too?
I don't think I have
That is correct, you did.
32.7.
32.7.
I don't see 32.7.
Good thing I took care of this stuff early.
I don't have any duplicates. You might have had extras.
I do have,
Yeah.
I do have, sir, I do have it.
32-7.
Thank you.
(32-7).
Okay.
Okay, and was this prepared by you or under your supervision?
Once again, under my supervision.
Okay. And is the information it contains true to your knowledge and belief?
Yes.
I'd like to mark this as Staff Exhibit 5, please.
So marked.
I'm afraid of the answer on the next one. Do you have staff, the response to staff data request 32.8?
I do.
And nobody
We
else
don't.
does.
We do not. Thank you, Lloyd. A for effort, though.
I think maybe I missed this folder. All right, the company's response to 32.8, was this prepared by you under your supervision?
Yes, under my supervision.
And is the information it contains true to the best of your knowledge and belief?
Yes, it is.
I'd like to mark this as Staff 6, please.
So marked.
Okay. And I think this may be the last one that wasn't handed out. 32.9.
I do have it.
Okay.
No. Thanks, Joe. For you, for me, here's some extras. There we
Ms. Oblak, did you prepare this, or was it prepared under your... Actually, it was prepared by Mr. McGettigan's office.
That is true.
Are you familiar with this response?
I was not, but I did just read it.
And is the information it contains true to the best of your information and belief?
I believe I trust Dawn McGettigan's response to this question.
All right, I think I will leave this out of the packet. Okay. Do you have response to OPC 24.1?
Could we go off the record for a minute, Your Honor?
Yes, briefly.
That's already been admitted as OPC Exhibit
OPC
5. So
OPC
you can
Exhibit
skip
5.
that one, Lloyd.
Yes. Okay, we'll skip that one. We will also skip OPC 27.2.
Are we still off the record? I don't think
Yes.
that one didn't
We're
come
still
in.
off the record.
It didn't come in, but it was from another witness, and
Okay.
and the same with 32.9. Okay, do you have 32 point... yes, you did have 32. Do you have
Back on the record,
32.4?
Mr. Spivak?
Yes, let's go back on the
All right,
record,
let's go
please.
back on the record.
Okay, do you have 32.4?
Yes, I do.
Okay, and was this prepared by you or under your supervision?
Yes, it was.
And are the answers complete and true to the best of your knowledge and information?
Yes, it is.
I'd like to mark this as Staff Exhibit 7.
So marked.
Okay. Do you have the response to Staff 32.2?
I do, sir.
And was this prepared by you or under your supervision?
Yes, it was.
Okay. And is the information true and complete to the best of your knowledge?
Yes, it is.
I'd like to mark this as Staff Exhibit 8, please.
So marked.
Do you have in front of you the company's response to Staff Data Request 22.13?
I do.
Okay. Did you prepare this response, or was it prepared under your supervision?
Yes.
Okay. And is the information it contains true to the best of your knowledge and belief?
Yes, it is.
I'd like to mark this as Staff Exhibit 9, please.
So marked.
Okay. And last, you have in front of you the response to Staff 22.19.
Yes, I have it.
And was this prepared by you or under your direct supervision?
Yes, it was.
And is the information it contains true and complete to the best of your knowledge and
It
information?
is.
I'd like to mark this as Staff Exhibit 10, please.
So marked.
And I would move that Staff Exhibits 3 through 10 be admitted,
No objection.
and further that Staff Exhibit 2 be held in abeyance until OPC has resolved its issue and we can get a final ruling on that.
Staff 3 through 10 are admitted.
Thank you, Your Honor. Can we go to your rebuttal testimony, please?
I'm there.
Okay. Let's start at page 9. And you had a brief discussion with counsel for OPC about the Washington gas order and whether or not that order had denied the SERP recovery. Do you recall that?
I recall that conversation.
Okay. You are aware, however, that in most recent commission orders from this commission, SERP has been denied?
I do believe that's true.
Okay, thank you. Okay. Can we go to page 2, please?
2.
Okay. At line 11, you make the statement that the cost of software are not contingent on the number of customers. Did you
Yes,
do
I see that.
Costs of software are not necessarily contingent upon the amount of plant either, is it?
The software used for the software that is owned by the company, however, there would be no need if we didn't have a transmission or distribution system.
There would be no need if you didn't have customers either, would there?
That would be true.
Can we go to the bottom of page 6, please? Now, you mentioned financial goals at line 20 to 21, including notably earnings per share and operating earnings.
Yes,
Now, the earnings per share and operating earnings, those benefit shareholders directly, do they not?
they do.
Okay.
Or strike that. Although they do, indirectly, we believe they also benefit the customers due to the way our goals are set up. They're to increase productivity and efficiency and, basically reduce costs. And accomplishing that produces less expenses, which we would then pass those benefits on to the customer.
But in fact, they're direct measures of the benefits the company provides to its shareholders, are they not?
They are. May I add one other item?
By all means.
One item that might be important to note is during our last litigated West Virginia base case, these expenses, these types of expenses were allowed, and the commission did determine that they had actually indirectly benefited the customers.
Can we go back to page 9, please? And down at lines 16 through 17, you note that 80% of surveyed companies offer SERPs?
Yes, I see that.
Okay. But not all of them do, is that correct?
According to that study, 20% would have not.
Okay. And even for the ones that do offer it, not all of them are allowed to recover that by their various regulatory commissions. Is that correct?
I believe we've gone over that, yes.
And you haven't presented any evidence that the companies that don't have SERP or aren't allowed to recover SERP have difficulty retaining personnel, have you?
Yeah, as in my testimony, we basically said that was difficult because, in essence, most of them did, and therefore, though, we do not have a study as such.
Thank you. Can we go to the bottom of page 12 of your rebuttal testimony, please? And you refer to the last litigated base rate case. It's at line 21. So the allocation should remain unchanged from the methodology in the last litigated base rate case. Did you see that?
Give me 1 minute.
Okay. That's line
Yes,
20?
I see that. Mm-hmm.
Okay, and this is the base rate case that happened roughly 25 years ago, is that right?
That is true.
Looking at page 13, also beginning around line 18, really 17, should not be required without identifying specific reasons why they all need to be updated within the specified time frame.
Could you give me 1 minute, please?
Okay. The second to last question and the response to that.
I've read the question and answer.
Okay, now you did not update them for this case, did you?
Due to the time availability, we did not have time to update the studies, and reviewing, basically we felt that there was no materiality effects that would have altered our results of the studies, and yes, at that point, therefore, the studies were not updated.
Okay. The next question, and the answer to it, you are talking about Staff Witness Baker's recommendation that the next rate case also include a cost of service study without a minimum intercept study. Is that right?
I'm sorry, could you repeat your question?
Okay. that question and answer, you are talking about Staff Witness Baker's recommendation that PE should submit along with its planned cost of service study, a cost of service study that does not include the minimum intercept study. Is that right?
Yes, I believe he recommended that if we continue to use the zero intercept, that we should actually produce 2 cost of service studies.
Okay, now, with respect to a zero minimum intercept study, that type of study is not universally accepted and admired, is it? Not everybody agrees it should be used.
I do agree that not everyone uses that methodology, although it is supported by NAROC.
And with respect to that support by NAROC, NAROC makes it fully optional, does it not? It's neither an affirmative or a negative recommendation.
It's not a requirement.
Right. Okay. And a minimum intercept study will generally yield results that show higher customer-related costs, does it not?
I believe the purpose of the zero intercept study, as I recall from NAROC, is to determine the appropriate portion of an account that would relate to customer versus demand.
And the result when you use it is that customer cost will generally come out higher, is that correct?
I do believe that's correct.
Okay, page 15 of your rebuttal testimony. Okay, now, right at the top of the page there, you make the statement, cost of service customer class allocations were performed in a manner consistent with the company's last litigated base rate case, and it is premature to evaluate whether the ACP methodology should be used in the company's next base rate case. Is that right?
I have read that. However, I will state that we, after reading the concerns of staff, we would include an evaluation of that information before our next base rate case.
Okay. We can't actually fully evaluate the value of...
Oh, I'm sorry, sir. We would agree that to evaluate, basically take the data and determine if that's the appropriate allocation to use in the cost of service study.
Okay, thank you. All right, the last question and answer, or the second to last question and answer here, you talk about the additional expense of retaining large volumes of data, database sizing, storage, and maintenance. Wouldn't a larger number of customers increase the volume of data the company needs to store?
Could you repeat that question one more time?
I said, wouldn't a larger number of customers increase the volume of data the company needs to store?
Generally speaking, I would agree with that.
Okay. Thank you. That's all I have, Ms. Obeck. Thank you.
Thank you, Mr. Spivak. Mr. Trout, can you redirect?
Yes, thank you, Your Honor. Let's first clean up the record a little bit on the cost allocation manual, if we can, please, Ms. Oblock. You should have in front of you a binder that includes testimony from other parties' witnesses, including staff. Do you see that binder? Look, it's one of the other binders up there. It's up on the counter. You got to look at the. There's a. Do you want me to?
Yeah,
Could
go ahead.
Meredith
I
help?
believe
her?
it's the Efron, Garen. Oh, got the wrong book.
Yeah, that's it. Thank you. So, sorry about that, Laura. Could you please open to Ms. Poboreski's direct testimony. Let me know when you're there.
Okay, I'm there.
Now, could you go to page 17 of Ms. Poboreski's direct testimony? And I recognize, Your Honor, that this is not in evidence yet, but it will be, and just for ease of the Commission and everyone else in connecting the dots later, I think this is the most efficient way to get this information in the record. Okay, are you on page 17, Laura?
I am.
I'm sorry, Ms. Oblak. Could you go to line 13?
I'm there.
Okay. Could you first read to yourself lines 13 through 17?
I've read it.
Okay. Is it your understanding that this is the cost allocation manual document that Mr. Cleaver was asking you questions about earlier this afternoon?
Yes, it is.
Okay. And does Ms. Poboreski's testimony refresh your recollection as to, first of all, whether the cost allocation manual is part of the record in this case?
Yes, it does.
Okay. And does it refresh your recollection as to why and how it got into this case?
Yes, it does.
Okay. Finally, if you look at the last sentence, based on your reading of Ms. Poboreski's testimony, do you have an understanding of whether staff has reviewed the cost allocation manual that the company filed as part of its direct case?
Yes, it would appear that they had reviewed it.
And what is your understanding of whether staff has any concerns about the methodologies in that cost allocation manual?
Yes, it states that staff has no concerns with regard to the company's CAM.
And finally, if the commission was going to look for the CAM later, where would they find it?
Exhibit REV-21.
Thank you.
You're welcome.
Could we go back to page 4 of your rebuttal testimony?
Okay, I'm there.
Am I right in understanding that on page 4 you explain why the items in account 390 are first allocated to specific jurisdictions, the step 1?
Yes.
Okay. And do you remember a series of questions from Mr. Cleaver about how that step 1 relates to the document, the specific page from the NARUC guidance that's your exhibit LMO10? You remember that line of questioning?
Yes.
Okay. Now, I think I'm right in remembering that you agreed with Mr. Cleaver that nowhere on page 105, which is LMO10, does it say explicitly that you can or should do that step 1 that you're discussing on page 4?
Yes, it specifically doesn't get into that.
Okay. Is it your let's do it this way. What is your understanding as to whether doing step 1 the way you did it is consistent or inconsistent with the overall guidance provided by NARUC?
I don't believe just because it's not specifically mentioned that NARUC, that goes against what NARUC is presenting as acceptable approach.
So you're saying that doing it the way you did it is consistent with NARUC's guidance, regardless of whether that's spelled out on page 105 or not?
Objection. That wasn't the testimony, Your Honor, and that's a leading question.
I'm going to allow it, Mr. Cleaver. It's pretty close to my recollection of whether it was or was not consistent with NARUC. I believe that was your line of question, so I'm going to allow the question.
Do you need the question read back?
Could you, please?
Linda, could you read the question back?
So you're saying that doing it the way you did it is consistent with NARUC's guidance, regardless of whether that's spelled out on page 105 or not?
And I would agree with that.
That's what I have, Your Honor.
Okay. Thank you very much. Ms. O'Black, thank you for coming today. I have a couple of questions. First, with respect to the financial metrics on the associated with your incentive plans, long-term and short-term incentive plans. Are you able to separate out the portions of the plans that are based on financial metrics?
Yes, I believe that is, yes.
Mm-hmm. And have you done that in testimony?
I specifically have not done that.
Uh-huh.
I've just kind of viewed it actually at a higher level.
Can you tell me how much of these plans are, in fact, related to financial metrics?
I do believe there was a data request on that we responded to, but
Mm-hmm. But we're not sure if that's in the record. Okay, thank you. So, you've mentioned that you had some time concerns with respect to doing some studies that Mr. Baker recommended, is that right?
that is true.
Right. And how much time would doing those studies take?
We did have a data request on that, and I know it's more than a few months. From the guidance that we had gotten from a phone call, it definitely would take more than a few months, and then it's just trying to coordinate the people that need to get it done for you, and determining the expertise, and quite frankly, it was a real push to get this case together in order to meet the deadline that we had stated that we would in order to because of the Tax Cut Jobs Act.
Right. And that was about a 9-month period, was it not?
That was.
Right. Okay. So, were you here yesterday?
I was.
Okay. And did you, I asked some questions about whether there had been growth in the company in the last 25 years. And I believe we heard that there had been some significant growth over time, particularly in Frederick. Is that your
I do
recollection
recall
as
that.
well? Right. So, would you say that might have a material effect on jurisdictional studies? You know, a significant expansion of customers in a particular state versus another state?
We believe that because the highest percentage for Maryland of customers is residential, it's 80-some+ percentage.
Mm-hmm.
Normally with residential customers, they pretty much have the similar type demands and equipment versus the higher, industrial and commercial type customers. So we did believe that, our study still reflected results that would be reasonable for this case.
Mm-hmm. Did you do any of these studies when you filed the rate case in West Virginia about 5 years ago?
It's actually a good point. We didn't redo the studies, and the West Virginia Commission did not. No one had a problem with the fact that we hadn't updated the studies. Nobody went on record with having any kind of problem. So that in itself, too, reinforced our assurance that, at least from West Virginia's standpoint, they didn't have an issue with it.
Okay. And when was the prior rate case before that one in West Virginia, if you know?
So the 2014, they didn't have an issue, and the 2006 case.
2006. So you
but-
filed, there was a case in 2006 in West Virginia as well?
Yeah, but these same studies that we're using in this study were also used for the 2006 case.
Okay. So I believe that Mr. Valdez suggests in his testimony with respect to a depreciation study, but I'm wondering whether it would apply to other studies as well, that when you file a rate case, you want to ensure that the period covered by the new depreciation study, in his quotation, most closely corresponds to the new test year. Do you agree with that point to the extent that you can with respect to a depreciation study?
From my recollection of the studies that I've been involved with, I believe it's more of a standard practice to update the separation studies. Well, only because since the 3 West Virginia-based cases I had been involved with and this one Maryland, we haven't updated the cost of these studies that were used for the cost of service, but I know we have had updates since more frequently for the depreciation studies. So with that, I would say there's more of a emphasis on of an impact with a depreciation study versus these for the cost of service.
Right. So it's your position that the studies that were done at least 25 years ago, maybe more, I don't know when they were performed with respect to the last rate case, that those would remain in effect and have value over a 25-year period when we've had a number of different changes, potentially industry coming and going. We have evidence from the company of significant growth in Frederick, and it may not be all residential. And you assert that it's still valid to rely on studies that are that old?
We do believe that for this case, they did produce reasonable results. However, we do feel that for our next base case, and given that we're not, another Tax Cut Jobs Act doesn't occur, we do believe that the studies should be updated.
Mm-hmm. And do you have a sense as to when that next case might be?
I do not.
Is it possible it could be 25 years?
I have a feeling that's not going to be the case. But
Okay. Thank you very much.
You're welcome.
Mr. Richard?
Yes, I think really most of my questions have been answered, but I am interested in this something brought up by Mr. Spivak about the zero-intercept methodology, and so that was something that the company thought was appropriate 25 years ago. I guess that's what we determined in 1994.
Yes.
Is there something it's different or unique about your service territory, why you would use that, and many other utilities and other states don't use that methodology 25 years ago?
I will admit that I personally am not really aware of maybe from a more of an engineering standpoint, but this is another item that for our next base case we believe we should look into to determine whether we should in the future would it be applicable, basically review to determine should that study still be continue to be used.
Okay, but I think it was pointed out that it tends to really shift everything to customer-related costs, and you mentioned that over 80% of your customers are residential, so this could shift significantly many of those costs that otherwise might be better allocated. Is that correct?
Yeah,
I mean,
I-
if we were to go with this.
Well, I guess for me, just as more from an accounting perspective, there was one example that I kind of actually when I sat down to think about it, and there could be, so does it relate to customer? Does a cost relate to customer? So a system could be built for demand, but yet, you have a person that builds a house out in Timbuktu, and you still have to get the line out there with the pole, and that pole isn't related to distribution. So that's the way I was trying to think of it.
Right, and that's why I asked you the question. Does the PE of today, does it still look significantly like the PE of 25 years ago? And have things changed enough that perhaps by using this methodology, we may not be setting the most just and reasonable rates for your customers without reconsidering that allocation methodology?
Yeah. Possibly Ray Valdez might have a little bit more of a sense to that. I hate to do that, but I personally didn't get into evaluating everything with, all the aspects of the system, and I would say more so relied on the fact that we filed these used these studies in the last West Virginia cases, and they themselves didn't have a problem with it. And then we had the time constraint.
Okay, I understand the time constraint, but again, I think it's our duty to make sure we're getting it right, and not knowing when the next rate case is going to be, these rates could be in effect for quite a while. Is that correct? So, and again, parts of PE is you would probably, is it true, have grown quite a bit, particularly in the Frederick area and up through Hagerstown and that.
Yeah.
They look significantly different today than they did 25 years ago.
I agree, and the only thing in my mind is I can just think of it as, because the base is highly residential, the fact that
They'll just even it out.
it's more often that the residential customer results wouldn't affect the studies. Those that are commercial and industrial would have more of an effect on those studies because of the different equipment and such type used.
Okay. And then I think the question's been asked, how long would it take to conduct these studies? We're obviously, Mr. Valdez will talk about the depreciation, but these studies based on, for the cost of service.
I believe each study in itself would be, we were told, months.
Months, not years, but months.
Yeah.
Okay. So that'd be less than a year. Okay. All right. Thank you.
You're welcome.
Thank you, Ms. O'Black. You've given very compelling testimony, so I appreciate it. Most of my questions have been asked and answered, specifically around SERP and the company's burden to prove that it's the ratepayer's burden should a SERP exist in your company, and not the shareholders' burden. So I appreciate that. So I won't go down that line. But I did want to ask you, in follow-up to both Commissioner Herman and Commissioner Richards' last question, about commercial and industrial in Western Maryland. Because I was in the legislature since '95. I'm well aware we've lost significant manufacturing from Cumberland, from Hagerstown, from Frederick even, over the last several decades. Significant loss of manufacturing institutions, jobs, and facilities. Couldn't that affect these cost of service studies dramatically? I think you said that yourself.
Yeah, the only item is that percentage-wise, those are a much smaller percentage of the percentage-wise of the customers that we serve.
I understand.
So a lower impact.
But not of the load. There's significant load, right?
That is true, and quite possibly Ray could have, from an engineering standpoint, have more information on that.
Point being, it'd be reasonable to conclude that maybe we ought to do an updated study considering the changes in both residential and specifically in heavy industrial and manufacturing, which has bled out of Western Maryland, to my knowledge.
We are definitely not against updating our studies.
Yeah. All right. Thank you. I think it's important that we recognize the importance of these studies and updating them, and not relying on outdated studies when the landscape has changed dramatically. Not the mountains, but your customer base. Thank you. Thank you, Madam Chair.
Thank you, Mrs. Oakley. Mr. Trout, you'd like to call your next witness?
Mr. Gunderson's going to take the next witness, Your Honor.
Okay, Mr. Gunderson.
Yes, Your Honor. The company would like to call Mr. Valdez to the stand. May you please state your name for the record?
My name is Raymond E. Valdez.
And what is your business address?
Business address is 800 Cabin Hill Drive, Greensburg, Pennsylvania, 15601.
Who is your employer and what is your title?
I'm employed by First Energy Service Company. My title is Director of Rates and Retail Service, of Rate and Regulatory Services, and my work is done primarily for the operating companies of Potomac Edison, which serves obviously customers in Maryland as well as West Virginia, as well as its sister operating company, Monongahela Power, which serves customers in West Virginia.
Thank you. Do you have before you a document titled The Direct Testimony of Raymond E. Valdez, consisting of 46 pages and 24 exhibits?
I do.
Your Honor, may I please have this document marked as Applicant's Exhibit
23.
23? Thank you.
So marked.
And do you also have before you a document titled Supplemental Direct Testimony of Raymond E. Valdez, consisting of 4 pages and 24 exhibits?
I do.
Your Honor, may I please have this document marked as Applicant's Exhibit 24?
So marked.
And lastly, do you have the document entitled The Rebuttal Testimony of Raymond E. Valdez, consisting of 45 pages and 8 exhibits?
I do.
Your Honor, may I please have this document marked as Applicant's Exhibit 25?
So marked.
Were these testimonies prepared by you or under your supervision?
Yes, they were.
Do you have any corrections, additions, or deletions to these testimonies?
No, I do not.
If I ask you the same questions today that are contained in your testimonies, would your answers be the same?
They would.
And are the testimonies true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, we would respectfully move for the admission of Applicant's Exhibits 23 through 25.
Seeing
No
no objections,
No objection, Your Honor.
they're admitted.
All right, thank you. Before making Mr. Valdez available for cross-examination, may I please have him answer Commissioner O'Donnell's data request?
Yes, thank you.
Okay. Mr. Valdez, can you direct the Commission to the information that Commissioner O'Donnell requested?
Yes, if I understand the request correctly, Commissioner O'Donnell, you were asking about the regulatory liability. There's actually two. There's one that began on January 1 of 2018, went through September 30th. That was the one where the Commission ordered us to return that to customers, and we did primarily during the month of November of 2018. And then, if I understand the question correctly, you were inquiring about the second regulatory liability. That one began October 1st of 2018 and will run through conclusion of this proceeding. That in my rebuttal testimony.
Actually, it will run through the rate effective date.
I'm sorry. I stated that correctly. It would run through the rate effective date, which would be the late March time period of this year. In my rebuttal testimony, if you could return to Exhibit REV-29. I'll give you a minute to get there. 29 on my rebuttal. Okay, if you're there, this is a document that should answer your question. It contains two numbers that are in boxes off in the far right-hand column. The first number is the first regulatory liability, the one that's been returned to customers of about $4.9 million. The second one is the magnitude of the second regulatory liability that began on October 1 and then runs through the period until rates are effective from this proceeding.
Okay, thank you. Those were, just for the record, those were predicate questions because I got more questions along those lines.
I understand.
Okay, thank you.
All right, thank you, Your Honor. Mr. Valdez is available for cross-examination.
Okay, thank you, Mr. Genderson. Mr. Fields.
Yes, thank you, Your Honor. Mr. Valdez, actually, picking up on what you were just talking about, could you look at page 19 of your direct testimony, please?
19 of my direct.
Yes, 19 of your direct testimony.
Okay.
And let's see, if I look at the front page, this was filed August 24, 2018. And on line 4, you say the Commission should not consider the amounts deferred from January 1st, 2018 through the date of the order when rates are changed in this proceeding, because it is my understanding that any such flow back to customers of the interim deferral would be improper because it would constitute retroactive rate making. Do you see that?
I do.
Okay. And then you talk about how a little further down the page, you assert that the company is not earning its authorized ROE, and you reason that the company should not refund the what you call the interim deferral until the company is earning its authorized return. I'm looking like down at line 22 and over to the next page. Do you see that?
I do.
Okay. And so what is this? What is the company's currently authorized return?
The current authorized return, when you say return, are you talking about return on equity?
Well, I'm just referring to what you're referring to here at the bottom of 19 over to 20, when you say should be permitted to earn its authorized return. So, I mean, you can put it in either way.
Well, what it's referring to is actually twofold. One is the current authorized return on equity, I guess I should specify, is 11.9%. But even if you look at the authorized return on equities for our peer utilities in Maryland, even then it doesn't even equal that magnitude.
Okay. You're familiar with case 9473, correct? Dealing with the Tax Cut and Jobs Act?
Yes, I am.
Okay. And in that case, I believe the company also argued that the refunds at issue would constitute single issue rate making. Are you familiar with that?
I am familiar with that case.
And you're familiar with the company making that argument in that case?
Yeah, that's a high-level paraphrasing. That's not the full argument, but that's a
Okay.
general high-level synopsis.
Okay, thanks. And also raise this under-earning point as well in opposition to a refund in that case, correct?
That's correct.
And then the Commission issued an order, it's number 88860, on October 5th, 2018, disagreeing with those positions, correct?
Yes, I actually referenced that in my rebuttal testimony.
Right. Now, you filed supplemental testimony. Do you have the date when you filed supplemental testimony in this case?
Yeah, the supplemental direct testimony, which was the only difference between the original August 24th filing and the supplemental direct filing on October 22nd, was the original filing was a what we call 9+3, a 9 months actual data and 3 months forecast. And so the supplemental direct on that was filed on October 22nd per the procedural schedule, replaced the 3 months of forecast data with 3 months actual so that the test year is a fully historical test year.
Okay, but you did not change your recommendation with regard to the what you call the interim deferral in your supplemental direct testimony, correct?
Correct, because the purpose of that supplemental direct filing was to update the 9+3 with 12 months of actual data.
Okay. And in the October 5th order, the commission, I think you referenced this, ordered PE to issue a one-time bill credit for the regulatory reliability through September 30th, correct?
That is correct.
And you said you have done that.
Yes, we have.
And it also ordered you to track the regulatory liability from September 30 through the end of case 9490. And I believe you just pointed us to some of those numbers, correct?
That is correct.
All right.
I believe the start date, though, would be October 1st rather than September 30th.
All right, thank you. And now if we could turn to your rebuttal testimony. And specifically page 17. Line 12, you say, consistent with my direct testimony, the company believes the deferral for this short-term period as of October 1 should be allowed to be retained by the company. It says the refund ordered by the commission for the January 1, 2018 through September 30 period was considered a, quote, extraordinary, end quote, issue outside the context of a base rate proceeding. You see that?
I do.
And then on page 18, you again raise the under-earning argument, correct?
I do.
And then down on lines 15 to 18, you state that the concluding the customer is getting a refund January, September of 18, it would strike a fair balance. Those are your words there on line, or actually your words are strikes a fair balance between customer and company on line 18 to allow the company to retain the amounts accrued as of October 1st. Now, in your rebuttal testimony, you don't mention the issue of single issue, the argument single issue rate making, correct?
I don't.
And do you still maintain, in light of the Commission's Order 88860, that a refund of the October 2018 to March 2019 amounts would constitute single-issue rate making?
Well, I think whenever you look at a single aspect of rates, because you got to remember that distribution rates are an aggregate of hundreds of different items. And when you take a look at one aspect of the rate in isolation, then that, by its definition, is a single issue. The Commission had addressed that in its order, so there was no need for me to bring that up again.
So you're saying you still think that's the case, you just didn't mention it, and you still think it would be single-issue rate making, you just didn't bring it up in your rebuttal, is that what you're saying?
Well, I didn't bring it up in my rebuttal because the Commission already addressed that in their order.
Okay. All right. Let's step back for a second. I assume you were here yesterday?
I was.
Okay. Would you agree with Mr. Sears' characterization of the company's reliability performance at this time as stellar?
I don't deal with reliability in my job function. I will have to defer to the testimony provided by Mr. Sears as it relates to reliability.
Okay. You certainly don't disagree with it, I take it.
I can't take a position one way or the other regarding his testimony.
Okay. But whatever reliability performance the company has achieved, you would agree that that's been achieved without a rate increase or a surcharge, correct?
That has been achieved within the context of deteriorating earnings. I would agree with that.
And could you explain to us how Potomac Edison accesses capital?
When you say buying capital,
I
like
said
a transfer,
accessing capital.
accessing
Yeah.
the
How does the company get capitalized?
access to the capital markets?
Yes.
Oh, okay. I'm sorry. Well, that's achieved through our approach to the investment community and the acquisition or the attainment of debt. We retire certain debt at other times and acquire new debt, and so that's part of the funding mechanism. Is its acquisition is through those debt issuances.
And are you referring to debt issuance at the Potomac Edison level?
No,
At what level?
at the level provided by the market. Whenever
I'm sorry, I meant at what company level? What
Oh.
company is going out to the market?
oh, I'm sorry. That's Potomac Edison.
Okay. So Potomac Edison is accessing the debt market, and your shareholder is First Energy, correct?
Yes.
Okay. And okay. Now, do you believe that the company needs excessive depreciation expenses from this case in order to maintain its stellar reliability performance?
What do you mean by excessive?
Well, anything above what the commission would find to be reasonable in this case.
So, that's where I'm struggling with what you're saying. If something that the commission orders as far as a depreciation rate, you're saying that that's excessive what they ordered?
Yeah, no, I'm saying, do you think at this time that the company needs depreciation rates that are more than reasonable depreciation rates in order to continue its reliability performance?
Well, I think the premise of that's flawed. As I put in my rebuttal testimony, the level of depreciation expenses is not excessive. So I'm with that correction. Now what's the question then?
Well, I understand that you say in your rebuttal testimony that you think that the level requested is reasonable, but what I'm asking you, is there any reason for the commission to think that they need to allow depreciation rates greater than what the commission thinks is reasonable in order for the company to maintain its reliability performance?
That's where you're losing me. I'm struggling with the premise that the commission orders a depreciation rate and then has us charge a different depreciation rate.
No, I'm saying, how much depreciation expense are you asking for on a yearly basis from ratepayers in this case?
I believe, from my recollection of the income statement, it's about the mid 30 millions, maybe 34 million, somewhere around there.
Okay, so you're asking for, on a yearly basis, $34 million in depreciation expense to be included in rates, correct?
That's correct.
Okay. If the commission finds that that level of depreciation expense is not reasonable and decides on some lower number, it's not your testimony, is it, that that lower but reasonable depreciation level is going to impact the ability of the company to maintain its reliability performance?
I can't speak to the specific effect. You're talking about a ripple effect, and you're going pretty far down the chain in terms of the ripple effect. My rebuttal testimony, I talk about the practical effects that, for the key credit metrics, I can turn to the exact page if you'd like, but I believe it was Mr. DeSendis yesterday that said that utilities can access the capital markets. It's the cost. And to the extent that our key credit metrics deteriorate, and that causes an increase in our cost to acquire that capital, and that increase ultimately gets reflected in customer rates. That's what I'm testifying to.
So, are you saying that if the commission disagrees with you about what a reasonable level of depreciation expense is, that that's somehow going to well, okay, you're saying that that would not impact the company's ability to access the capital market and obtain the capital it needs to run the company, including its reliability programs. Is that right?
What I'm saying is, as soon as I saw the submittal of OPC's testimony, I believe it was on November 20th, I talked with our Treasury Department, and they expressed a concern, a very grave concern about the view of the markets of an $11 million decrease. And diving into those numbers, seeing that the effect of the cash flow, not a change in the cash flow, a seismic change in the cash flow, would be viewed negatively by the investment community.
Okay. Now, the depreciation level that you are seeking, this $34 million approximately, that is supported by a depreciation study that was performed in 1994, correct?
Yes.
Okay. Now, we've heard in testimony about a study for the for PE's West Virginia operations to support a rate filing in 2013, correct?
Well, you're close. It was a depreciation study for 2013 assets for a filing in 2014.
Okay. But the company has chosen not to perform an updated depreciation study for this case, correct?
It's abbreviated to say that the company chose not to perform. It's a cascading or a multitude of events which resulted in that decision. So the company ultimately could not, in a reasonable time frame, do an updated depreciation study in order to pass through the impacts of the Tax Cuts and Job Acts as soon as possible to customers.
Mr. Fields?
Yes.
We're going to need to take a break shortly, and
we
if you
can
want to
take-
just pick a good time, is now a good
Right
time?
now would be a good time.
Okay. All right, we'll adjourn for until 10 after 3.
Thank you.
We're adjourned.
Thank you, Your Honor. Yes. I think we were just talking about a depreciation study filed. It was I think you said it was a 2013 depreciation study filed in a West Virginia rate case in 2014. Is that correct?
That's correct.
Okay. Who performed that study?
The individual or the firm?
Well, both, if you know.
It would be Mr. Spanos from Gannett Fleming.
All right, thank you. And I think, and do you recall from discovery we learned that that study took approximately 6 months to perform?
The study took 6 months. That's not the time frame involved in a depreciation study. That's literally Mr. Spanos' time.
I don't think I understand what you're saying. I mean, in discovery, he was retained. I believe he said he started work, and then 6 months later, he filed testimony.
What Mr. Spanos said is correct, but that's not the full range of what would be considered a comprehensive depreciation study. You can't underestimate what's involved before in this instance, the consultant, Mr. Spanos, before his work begins. That actually began during the summer of 2013. What predicated that whole case, as well as that depreciation study, was a significant event that happened in our West Virginia service territory. It was the purchase of 1,600 megawatts of Harrison Power Station. It was literally over $1 billion transaction, and it affected one aspect of the rates. And you have to remember that West Virginia is vertically integrated, so it's distribution, transmission, and generation. And so we evaluated during it would have been the summer of 2013, the anticipation of what needed to be done for that, because we were in the midst of settlement. And we understood that with such a significant change in rate base at that time, in the generation rate base, as well as a $1 billion transaction, we evaluated whether or not it made sense if we should do a depreciation study if that case were to be approved by the Commission. We agreed in settlement. It was mid to late August of 2013, we followed that with the Commission. And so we'd already begun our depreciation work prior to that. That case was approved, the settlement was approved by the Commission on October 7th of 2013, and with that approval, then we knew that our preliminary work for depreciation would go forward, and that's whenever we began the supplemental information that's needed for any type of depreciation. It's voluminous data. It's going through all the company records, because the one thing we did not want was, at that, it was Mr. Spanos who we retained. We didn't want to retain him and then have him sit around for a couple months waiting for data. So it's the several months in advance of that is what allowed us to prep for that. Mr. Spanos' testimony was submitted in May, so it was a little shy of a year, the entire time frame involved in that West Virginia rate case and subsequent depreciation study.
All right, well, okay, so you're saying now that there is some amount of prep work that needs to be done in order, prior to turning that over to a consultant to do the depreciation study. Is that what you're saying?
There is a large amount of prep work that needs to be done.
And I think during that long answer you just gave, you talked about spending a couple months on that. Is that right?
It would have been more than a couple months. Since we received the order on October 7th of 2013, that's a full 3 months there, knowing that we had Commission approval. But prior to that, then we were doing evaluations to determine whether or not a depreciation study was even warranted, and if it was warranted, who would that person actually be?
Could you look at to your left there? There's two documents, two one-page documents. If you could look at the one that is the response to OPC data request 30, number 6. Do you have that?
I do.
Your Honor, I'd like to mark that as OPC Exhibit 4.
4? I'm on 6, Mr. Fields.
Oh, sorry. Our list is off. OPC Exhibit 6, please.
So marked.
And I just need to get Mr. Spivak a copy. Now, this response says that Mr. Spanos was retained to perform consulting services, in this case, on November 22nd, correct?
That's correct.
And he provided rebuttal testimony in this case on December the 20th, I believe. Is that correct?
That's correct.
So according to this, Mr. Spanos and his firm were available as of November 22nd of this year to provide testimony to be filed on December 30th, correct?
Yes, to be clear, you said to file testimony on what date, I'm sorry?
December 20th.
Okay, December 20th. Yes, to be clear, soon after we saw OPC's testimony, we reached out to Mr. Spanos to determine his availability, because there was no guarantee that he would have been available. So we determined his availability, and this was not to provide a comprehensive depreciation study, and I think Mr. Spanos will agree to that I believe it's on Friday. What this was for him to take a look at the life analysis provided by Mr. Guerin and to determine whether there was any reasonableness to it and to evaluate that on our behalf, since he's a leading expert in the field. Fortunately, he was available. If he was not available, then we would have had to look for somebody else.
And he was available on 2 days' notice, it appears, correct?
He was.
All right. Have you provided any evidence that Mr. Spanos and his firm was not available to perform a depreciation study for the company prior to this filing of this rate case?
We did not provide any evidence about his availability, no.
All right. Any evidence regarding the availability of any other firm to provide a depreciation study prior to filing this case?
No, we did not provide evidence regarding that because we did not reach out to Mr. Spanos nor any other firm.
Okay, thank you. Now, are you aware that the Tax Cuts and Jobs Act was introduced in November of 2017?
I'm not sure when it was introduced. I believe it was signed into law on December 22nd of 2017.
Okay. And this case was filed in August 24th of 2018, correct?
August 24th, 2018. Yes, that's correct.
And it is your testimony that the company, that there was no way the company could react to the Tax Cut and Jobs Act and the possibility of a rate case and accomplish a updated depreciation study prior to filing this case?
I think that mischaracterizes. I think to understand it, you need to determine the sequence of events. The signing into law of the TCJA, the Tax Cuts and Jobs Act, was very complicated. I think anyone can attest to the Internal Revenue Code is so voluminous. It's measured in inches in thickness rather than in the number of pages. And after it's signed into law, then our tax department, as well as other departments within First Energy, as well as all other utilities, were determining what the impact was. What's to be done? We simply did not know on December 22nd or even into January exactly how we were going to enact this. We had evaluated multiple scenarios. And I think as I laid out in my direct testimony, we determined that since due to the passage of time, we didn't have any recent income statement or balance sheet, rate base items and so forth in order to appropriately calculate the impacts. So it wasn't until early to mid-February that we even made the decision that we should even file a base rate case. And that was reflected in our February 15th letter to the Commission that, yes, we indeed intend to file a base rate case. And it's one thing to say you're going to file a base rate case. It's another thing to actually provide some parameters involved with it. And we did not want to essentially leave the Commission guessing. Yes, they could understand that the company would be filing a base rate case, but the big question is when. When would the rate case be filed? When will customers see rates as a result of that? That's whenever we put parameters around it to give the Commission assurances that it will not drag on forever, that we would be filing a base rate case during the third quarter of 2018. After February 15th, after we submitted the letter, then we went through the preparations to determine exactly what was needed for a filing of a base rate case. The other thing you got to remember is that the personnel that existed at our last base rate case no longer work for the company. So this is literally creating everything from scratch, determining all the different items. And there are, as I'm sure you're very well familiar working with other utilities, is that there are numerous items that have to be done, numerous evaluations. And then one of the evaluations that we did was the depreciation. That's whenever we did the evaluation to determine, is our depreciation expense reasonable? That's the first threshold test. And we went through the analysis, which is essentially replicated in my rebuttal testimony, that looked at the reasonableness of our depreciation expense, because that's ultimately what the customer is going to pay. You could look at the hundreds of little items that make up individual factors within a depreciation rate or the various factors regarding that, but ultimately the depreciation expense is in the revenue requirement, and that was the factor in determining, is it reasonable what we're charging customers, and it fell right in the middle of the zone of reasonableness. And then to add on to that, I guess I should add that there was another item that Mr. Sears mentioned yesterday, was timing. We were concerned to make sure that we got this case in front of the Commission as soon as practical. And we knew that based upon our experience in West Virginia, there is months lead time prior to even retaining a depreciation expert. It takes months to do a study, and then there's another factor that's peculiar and specific to just this case. And it's something called ARAM, Average Rate Assumption Method. And I guess to be sensitive to Commissioner O'Donnell, yesterday he mentioned something about nuclear engineering or nuclear physics. And I personally would rather sit in a 12-hour lecture of nuclear physics than a 30-minute lecture of ARAM. It's that boring to listen to. But what happens with ARAM is that it's fundamentally tied to what the depreciation rate is. As the depreciation rate slows or accelerates, ARAM changes. So if the depreciation rate were to extend to get longer, now it takes a longer period before the book depreciation exceeds tax depreciation. That lowers the ARAM, increases the revenue requirement, and it works in reverse too. If you accelerate it, then ARAM is faster, and that lowers the revenue requirement since that's a deduction. That's another evaluation, and that's extraordinarily tedious evaluation. It was literally whenever we provided a staff data request about the ARAM calculation, it was over 420,000 lines of data just to get to ARAM. So the depreciation results have to run through the ARAM model to determine what is the effect, because even though if depreciation rates will decrease, rates will have some offsetting increase through the ARAM, and it will work in reverse. That's another factor. So that keeps on adding on, and then after you have all that data, then you have to run it through the revenue requirement model to factor all those items in. If you add all those items together, you're probably pretty close to a year. And that leads to my reluctance in my rebuttal testimony about the time frame in the depreciation study, because I know what I know. I don't know what I don't know. I don't know what type of problems that we're going to run into. And what I didn't want to do was to signal to the Commission on February 15th we were going to file a base rate case, and then sit here today not filing a base rate case, still waiting upon all the analysis to be done, it didn't seem to be prudent to wait that long, to have the commission wait that long to put a base rate case in front of them. So that was another determinant factor involved in whether or not we had the time to do it, and whether or not it was even necessary, since the depreciation expense fell within the zone of reasonableness.
You work for First Energy Services Corporation, correct?
I do.
How many utilities does First Energy Services Corporation serve?
There are 10 operating companies under First Energy.
And
Well, let me clarify. It's under First Energy is the 10 operating companies.
Okay. How many customers are served by those 10 operating companies?
I don't know.
Does First Energy Services have a tax department?
Yes, we do.
Okay. And is it your testimony that nobody at First Energy Services had thought about any of these issues you're discussing as being so complicated prior to February 15th of 2018?
They were working, you bring up a very excellent point. They were working on it not for just one utility, 10 utilities. So it was a monumental task for them to figure out not just what's going to happen for just Potomac Edison, but for the other 9 operating companies and the various states we serve, and discussing that this was not certainly unique to First Energy. Whenever we were evaluating scenarios in January, I was pulling down documents from Michigan for the utilities had to file documents. I believe it was at the end of January. AEP, a very significant utility as well, had in those documents this clarity that just simply could not be obtained at that time, and the utilities just simply weren't sure exactly what needed to be done because it was so complex. There were so many moving parts, and when I testified on this exact same issue in West Virginia last year, in May, talking about the changes in current taxes and the changes in ARAM. This was in May, and not all utilities knew exactly how to incorporate everything. So this was not a situation unique to First Energy.
Potomac Edison, Maryland has not filed a rate case forgetting the number of years, about 25 years, correct?
Yeah, the last decision was in 1994.
Right. Has there been any review? So, I guess what I'm having trouble understanding is that, are you saying that the company has not reviewed in the meantime on a periodic basis any of these issues regarding depreciation and being prepared to update a depreciation study in all that time, or since then?
I don't. In the entire 25 years time period, I wasn't in the position I am, so I can't speak for the people prior to me. But we do evaluate whether or not base rate cases need to be filed, whether or not there's justification, and when you file a base rate case, we determine evaluation of whether or not a depreciation study needs to be filed.
And I'm sorry, how long have you been in your position?
I have been in my current position for about 3 years.
Okay. And during those 3 years, there hasn't been any thought to say, maybe we ought to evaluate whether, we haven't had a depreciation study since 1994 for Potomac Edison, Maryland. Maybe we ought to get prepared to do that?
Well, to make that determination, you need to determine what is the purpose, what is the business decision for this. It sounds as though you're trying to generate a data point. I mean, as OPC admits that a depreciation study doesn't have precision associated with it. There's a great deal of subjectivity associated with it. And so if we do a new depreciation study, now we have a data point. Now what do we do with that data point? We do a depreciation study a few years later, now we have a different data point. What do we do with that data point? So it's a matter of expending resources to gather data points and just have it sit somewhere and not sure what to do with those data points.
All right. You've reviewed Mr. Guerin's direct testimony, correct?
I have.
Do you dispute that, well, I'd say he discusses in there the Commission's adoption of the present value method, also known as FAS 143 method, for estimating net salvage expenses? You recall that?
Yeah, it's what the SFAS, I hope I don't butcher that terminology, but it's SFAS 143. He discusses that, as well as Mr. Spanos in his rebuttal testimony discusses that as well.
Okay. Do you dispute that the Commission has adopted the present value method, or the SFAS 143 method, for estimating net salvage?
It's my understanding that the Commission has done that. It's my understanding that it's the only commission in the Union in all 50 states that has done that. And I believe Mr. Spanos talks about that, and certainly he would be available to talk about that on Friday. And I believe his concerns are warranted, and so perhaps that's something that should be revisited.
All right. Now, is it your understanding that the Commission adopted that method to recognize that a dollar received by the company is worth more, a dollar received today is worth more than a dollar received in the future, say 20 years from now?
That gets into the specific details of that. That's a question that Mr. Spanos can better answer.
All right. How about this? Because you do testify about depreciation. Do you agree that depreciation rates should balance cost responsibilities between current and future ratepayers?
When you're saying depreciation, what do you mean by depreciation? Can you explain what you're talking about?
The level of depreciation expense?
Oh, you talk depreciation expense. Okay. Well, the depreciation expense would be a direct result of the depreciation rates. And those depreciation rates, the current ones, are based upon a Commission's decision at that time that approved those. And then whether or not those depreciation rates change would also be a determination of what the future depreciation expense is. So I guess I don't really understand your question, is that the depreciation expense is related to the depreciation rates.
Well, okay, let me try the question again. Do you agree that depreciation rates should balance cost responsibilities between current and future ratepayers?
Well, I think Mr. Spanos can talk about the derivation of depreciation rates. I don't think whenever they do calculations of depreciation rates, they take a look at those specific factors. What we'll take a look at whenever we see the depreciation rates is the reasonableness of that. And if there's outlying reasons as to why it's reasonableness, that's when we'll need to have a discussion as to does this analysis produce unreasonable results.
All right, let me try the question this way. Would you agree that if current depreciation rates are higher than a reasonable level, then that would unfairly burden current ratepayers? Let me just leave it at that.
I guess I don't understand how you're talking about unfairly burdening. That whenever depreciation rates change, they're going to change on a going forward basis. Are you talking about this on a retroactive basis?
I'm not talking about changing. I'm just talking about the level. If you're asking for $34 million of depreciation expense, which is based on some set of depreciation rates, I'm just asking if you would agree that if that level is too high, that would unfairly burden current ratepayers.
And I guess that's where you're losing me. If the Commission determines that it's too high or too low, then it changes, and then it changes for future customers. But I'm being lost on the retroactivity of prior customers.
Well, maybe my use of current is a bad way to say it. Would you agree that depreciation rates should balance cost responsibilities between the customers who are going to pay rates during the rate effective period and customers who are going to pay rates sometime well out in the future?
I believe the depreciation rates, the calculation, is as laid out, or is probably best explained by Mr. Spanos, is how the rates are calculated. That's the determination of depreciation rates.
Now let me try this. Do you agree that the Commission has found that the present value methodology recognizes the time value of money to carry out an equitable balancing between customers paying rates now or in the near future and customers paying rates in the more distant future?
Well, that seems to be a variant of the prior question as to the SFAS applicability, and Maryland being the only state that uses that, and that's how Mr. Spanos can address the more specific details of that and whether or not that should be evaluated.
Okay, well, my question was, do you agree that the Commission has found that the PV method recognizes the time value of money to carry out the balancing of interest between current and near future customers and future customers? Do you agree that that's what the Commission has found?
I don't know that the specific details of the Commission's determination in those prior cases.
Okay. Would you agree that the depreciation rates you propose to underlie the depreciation expense you do not reflect the present value method?
I'm sorry, can you repeat that?
Do you agree that the depreciation rates you propose to use to set rates in this case do not reflect the present value method?
I would agree that the existing depreciation rates, if you take a look at one component, because you can't look at just depreciation rates in isolation and say just SFAS, just life. It has to be a comprehensive. It does not currently include the SFAS, but then there also needs to be a consideration of the life as well, because looking at it in isolation provides an incomplete picture.
All right. Do you agree that applying the present value method lowers depreciation expense?
From my understanding, and Mr. Spanos can correct me, I believe that it could lower it, and then you could have offsetting increases in the depreciable life.
If you perform, I mean, well, I guess, well, I can ask him about that. Or, well, is it your understanding that what he was saying was if he did a study, if he did an appreciation study, he might have come up with different numbers for the remaining lives, I should say?
I think based upon his rebuttal testimony, he certainly would, because the lives from the life analysis done by Mr. Guerin are extraordinarily long.
All right. And what we can agree that Mr. Spanos has not performed any such analysis, correct?
Yeah, nobody in this proceeding has done a full comprehensive depreciation study.
That's something I can ask Mr. Guerin about. All right. Could you turn to page 10 of your rebuttal testimony, please?
Of my rebuttal?
Yes, please.
Okay.
In lines 5 to 9, you talk about a recommendation that a study, the new depreciation study, be performed in conjunction with the next rate case as proposed to filed separately in a year. And then you say this would ensure that the period covered by the new depreciation study would most closely corresponds to the new test year in the next base rate case. But isn't it true that you're asking the Commission to set rates for 2019 that based on a depreciation study that uses data from 1994 and earlier?
What I'm saying with this paragraph is that what I explained before about the parameters involved when determining the reasonableness of our depreciation expense and not wanting to delay or the filing of our rate case by 6 months or more from when we actually did file it, provided the opportunity to plan for a rate case as we traditionally would, then we certainly would be willing and offered to definitely file a depreciation study whenever we file a next base rate case, because we would have the proper and necessary lead time, not only to do the work in advance of whomever that we end up determining should do the comprehensive depreciation study, but also to run through our ARAM calculations to determine is there any effect, as we certainly would expect there to be a change, because ARAM is based upon the rates, depreciation rates, book depreciation rates in effect at that time, so any change results in a change in ARAM as well.
How have you derived the depreciation expense you're seeking in this case?
It's the book depreciation.
Well, I mean, could you describe how you calculated that?
It's the depreciation that ends up getting booked each month by the company, and then Ms. Oblak does the separation studies and allocations in order to get that down to a distribution level.
Okay. On what basis does the company book depreciation expenses every month?
On its approved depreciation rates.
Depreciation rates, and it multiplies those times the current rate base in the current rate base for each of those accounts. Is that right?
Not rate base, plant and service.
Plant and service. That plant and service changes all the time, right?
Yeah, plant and service changes. That's correct.
Okay. So what you're proposing to the commission is to take depreciation rates approved in 1994, apply them to balances here in 2000, and I guess it would be 2000 at the end of, at 12/21/2017, and derive an expense level to charge customers in 2019. Is that right?
I'm sorry. Can you repeat that? I didn't get the whole
not.
question.
You're proposing to take depreciation rates. Let me take it piece by piece. Depreciation rates are percentages, right?
That's correct.
2%, 3%, 4%.
That's
Something like that? Okay. And your proposal for depreciation expense is to take those rates, which come out of the 1994 study, take those rates, multiply them by plant and service balances from December 31, 2017, I believe, to create a depreciation expense that would then be used for the revenue requirement to be charged starting in 2019. Is that right?
Yeah. The depreciation expense we have is based upon the actual depreciation expense for the test year, using the method of applying the depreciation rate percentages to the plant and service.
All right. Just to make sure the record is clear on this, it's the depreciation rate times the plant in service as of December 31, 2017, correct?
No.
No, what is it?
It's the plant and service for the various months. What I provided in my exhibit was plant and service as of December 31st of 2017 to illustrate a calculation.
To illustrate a calculation. Well, what is the expense level you're asking for in this case based on?
Based upon the actual book depreciation expense.
When?
For the 12 months ended 12 months ended June 30th of 2018. That's the amount that we're requesting to be included in the revenue requirement.
Oh, okay. I see. So when I was saying December 31 of 2017, I was wrong there. It should have been June 30th of 2018 for those plant balances. Is that right?
No, the plant balances change each month, so it depends upon what the plant is in the various particular months multiplied by the depreciation expense.
And then, are you doing some kind of average of 12 months? Is that what you're saying?
But depreciation expense is an, I shouldn't say O&M, but it's the expense that's incurred during the test year.
It's okay. So it's a monthly value for all 12 months of the test year added up.
That's correct.
Okay. Could you turn to page 5 of your rebuttal testimony, please?
Okay.
Now, and I want to talk about this table 1. Now, am I correct that in this chart, you take the outcomes, the depreciation rates, from depreciation studies that were done on the assets of other utilities, not Potomac Edison, Maryland, and apply them to the rate base account balances of Potomac Edison, Maryland? Is that right?
Yeah, because what I'm trying to do there is determine, is the level of depreciation expense reasonable? That is what the purpose of this exercise was. And what I did was to take a look that if those rates were applied, those depreciation rate percentages applied to Potomac Edison, Maryland plant balances, what would be the resultant expense? And I did that for the updated study for Potomac Edison in West Virginia for 2014, as well as Monongahela Power, because they're sister companies that use the same facilities. The problem with that was, since those rates, I think someone may have, in testimony, inadvertently said they were rejected. Those rates were never rejected. What those rates were, they were agreed upon in settlement to not use. And since we agreed in settlement to not use them, it seemed only fair to, if I don't use the rates that the parties agreed not to use, well, what are the rates then for the exact same facilities? And that's whenever I use Potomac Edison's existing rates in West Virginia, and Mon Power's as well. And so that's the genesis of those as well. And then to take it one step further, I wanted to see what it would look like for Maryland utilities that had depreciation rates that weren't based upon a settlement, because there's no way I could realistically pull out settlement parameters that were buried within depreciation rates. But I did see that Delmarva had fully litigated rates, so I used Delmarva's rates. And they also produced a depreciation expense that was very close to the company's current depreciation expense. So that is the genesis and the discussion of what I'm trying to discuss within that table.
All right, but getting back to my question, the way you generated the green bars, which are all the bars except for your bar for OPC proposed, all of those bars are based on depreciation rates that were derived in studies performed on assets for utilities other than Potomac Edison, Maryland, correct?
Yeah, to clarify, it is for the distinction is they are Potomac Edison assets. I don't think anyone will question whether or not they're Potomac Edison assets. They definitely are. But they're assets that the company purchased in common. And the difference in the asset is, instead of trucking it over into Maryland, they crossed the river and hung the transformer over in West Virginia. So it's the same assets. It's just from literally the same company across the river. So we did take those percentages and apply them to what would be the Maryland plant and service base to determine the reasonableness of that.
Okay. But the only, well, I should say it this way. The only, I mean, you have retirement data, and you produce that data for Potomac Edison, Maryland, correct?
It was partial retirement data. It certainly wasn't retirement data that anyone could determine retirement assumptions, because what happened in 1997 is our system changed, and without appropriately reflecting those retirements that occurred prior to 1997, that the study will produce erroneous results, and that was something that Mr. Spanos pointed out as a flaw in Mr. Guerin's analysis.
So you're saying that the data you provided in this case was flawed?
No, what I'm saying is the data is the data that we have, but just like any data set, it's more than taking data, plugging into a formula, and seeing what a computer states. You have to understand what the data is before you get it, and then understand the results afterwards, or else you could easily be led down a path of incorrect information.
I want to go back to one of my earlier questions and maybe amend it a little bit. The only bars on this chart that reflect a depreciation study done on the assets of Potomac Edison, Maryland, are the OPC proposed bar and the PE Maryland existing bar. Is that right?
I'm sorry, can you rephrase that question?
Well,
Maybe I shouldn't say rephrase, repeat it. I didn't get
sure.
the whole question.
The only two bars on this chart that reflect depreciation rates derived using data on the assets of Potomac Edison, Maryland, are the OPC proposed bar and the PE Maryland existing bar, correct?
It's close. The only data that does is the PE Maryland existing. The OPCs aren't depreciation rates, they're life analysis rates.
And these, okay, leaving that aside, and the PE Maryland existing column is based on the study from 1994, correct?
Yes, it's based upon a 1994 study, and the delineation between Potomac, Edison, West Virginia, and Maryland is when you take the assets and you apply and allocate it for West Virginia, then you get the Potomac, Edison, West Virginia numbers, and you provide the inverse of that allocated to Maryland, then you get Maryland numbers.
The Potomac, Edison, West Virginia existing bar, when was that study performed?
I'm sorry, the Potomac Edison existing.
Potomac Edison, West Virginia existing bar, when was that update done?
That was based upon...
I'm sorry, that was a bad question. Potomac Edison, West Virginia existing bar, when was that study performed?
That was based upon assets as of the end of 2005.
Okay, and the updated, now the bar to the left of that, PE West Virginia updated, when was that study performed?
Well, the study was performed in 2014, but was based upon assets as of the end of 2013.
Okay. So updating the West Virginia study from 2005 to 2013 resulted in approximately a $7.6 million reduction in depreciation expense, correct? According to this chart.
It did.
All right. Now, neither of those bars are shown reflect the present value method, correct?
West Virginia, as well as the other remaining 48 states, do not use the present value method.
Okay. How about Mon Power existing? When was that? What's the basis of that column, bar, I should say? What year was that study performed?
Well, I guess to make life easy, West Virginia does not consider in rate making the individual utilities separately. It considers the utilities together. So even though Mon Power and Potomac Edison are the same or different legal entities, whenever rate making's done, rates are never changed for Potomac Edison, West Virginia, and not for Mon Power, and vice versa. One affects the other because a residential customer in Mon Power pays the exact same rates as a residential customer in Potomac Edison, West Virginia. So the results get aggregated. So anything that we did in Potomac Edison, West Virginia has the exact same time frame as Monongahela Power.
Okay, so existing would be 2005 and updated study would be 2013. Is that right?
That's correct.
And again, the Mon Power study does not reflect the PV method, correct?
It's the same answer, that West Virginia does not recognize that as acceptable.
Okay. The other sheet of paper that I left on the corner there and handed out before you took the stand is a response to OPC data request 30-6. Sorry, that's not right. Staff data request 24.3. Do you have that?
I do.
And this response was provided by Mr. Adams on November the 7th, correct?
That's correct.
And it asks about whether PE has reason to suspect that the cost of removal percentages developed in the 1994 depreciation study would be materially different than the cost of removal percentage associated with more recent data. You see that?
I do.
And the answer is the company has no reason to suspect that the cost of removal percentages developed in the 1994 depreciation study would be materially different than the cost of removal percentages associated with more recent data. So would that indicate to you that at least as of November 7, 2018, the company didn't have any concerns with the level of cost of removal percentages whether the cost of removal percentages from the 1994 depreciation study were materially different than today?
That would be an incorrect assumption.
But isn't that what the answer says?
No. What it's saying is that there wasn't a new depreciation study. And absent that, the company can't make a determination as to whether or not the cost of removal percentages would be different. Now, likely what's going to happen, the procedure would be the same. The percentages very well may be different, but to determine the changes in the percentages, you'd have to do a full comprehensive depreciation study that you couldn't just look at this in isolation.
Could I have just a moment, please? Sorry, I neglected Mr. Spivak here. Let's see, I want to go back to something we talked about a little bit earlier, but would you agree that depreciation rates that are higher than necessary today would be a burden on current ratepayers?
I'm still stuck on that premise. I'm struggling with the assumption that they're higher and not knowing higher than what, and higher in orders of magnitude. So the question leads multiple questions in my mind.
Well, I'm trying to ask you,
I guess what I'm trying to...
If the rates are higher than a reasonable rate, doesn't that burden current or near future customers?
I guess the problem I'm having is it's hard to make an absolute in terms of an answer whenever the question's general. So I have lots of questions regarding the generality of it before I can determine whether or not the question is always in the affirmative, always in the negative, or are there different flavors depending upon the specifics involved.
The company doesn't have an issue with having sufficient access to capital to fund necessary projects, does it?
I'm sorry, can you repeat that question?
The company does not have an issue with having sufficient access to capital to fund necessary projects, does it?
I currently don't know of any issue.
And the company is not reliant on the current level of depreciation expense to fund those projects, is it?
depreciation expense is certainly on a practical matter a factor, but excuse me, the concern I have isn't with the current level of depreciation expense. The concern I have is with cutting it by more than half. That's where my concern lies.
If the commission determines that some level, that the depreciation expense that you're requesting is too high and cuts it down and lowers that to some other level that it finds to be reasonable, but my question is, you would still be able, that would not prevent the company from having access to necessary capital to fund necessary reliability projects, correct?
Well, the question leads more questions in my mind, because whenever you're saying lower, it's not defined, so I don't know how much lower you're talking about. If you're talking about OPC's proposed level, then that's the same answer that I gave previously regarding the credit metrics that certainly causes myself as well as our Treasury Department concerns.
Company doesn't need the current level of depreciation expense in order to fund its reliability projects, does it?
That I believe that's the same question as earlier, and I can't speak to specifically with the reliability projects how those sources of funds are derived from just those reliability projects.
Well, I'll ask more generally then. As far as to have capital to run the company's not reliant on the current level of the proposed level of depreciation expense to fund the company, is it?
Well, it sounds to me like it's the same question from earlier, that as Mr. DeSantis testified, that the company can get access to the capital markets. It's just to the extent that there's lower credit metrics and a higher pressure on the company due to lower funds from operations, then that increases our cost to acquire that capital from the markets, which then ultimately results in increased costs to customers.
But the rate of return model is based on the idea that capital comes from investors, not ratepayers, right?
The rate of return model is based upon funding of sources from debt and equity.
Right, which is not depreciation expense, correct?
That's a difference without distinction.
But then, I mean, if we look at it like the depreciation expense is funding capital projects of the company, then isn't it then the case that the customers are being asked to pay a return on capital that they provided themselves?
No. I'll give you an example. Let's say that depreciation expense, we'll make the numbers nice and round. Say depreciation expense is $30 million, and capital is $60 million that's needed for any one particular year. What theoretically you do for the depreciation expense, you take it and retire debt. So you retire $30 million of debt, and then turn around and buy $30 million of debt immediately. And you're exactly where you are at $30 million from debt, and then you get the other $30 million from equity, and there's your on normal, approximately 50-50 cap structure, that's your funding sources.
So aren't you then saying there that the funding of capital for the company is just coming from ratepayers?
No, it's the same example. That's why I said it's a difference without distinction. If you take $30 million of depreciation expense and retire $30 million of debt and turn around and get $30 million of new debt, you're back to where you started from $30 million, and then you get $30 million from equity, and there's your funding for the $60 million of capital.
And customers are paying for paying return on all of that capital, even though half of it is coming from their payment of depreciation expense.
The return is the return on, or I guess depending upon how you're phrasing it, is only on the equity piece. The debt piece is just for payment of our debt service.
Your Honor, may I have just a minute?
Yes.
Thank you for your indulgence on this longer than I anticipated set of questions. I have nothing further. Thank you, Mr. Valdez.
Thank you, Mr. Fields.
Thank you, Mr. Fields. Mr. Spivak.
Thank you, Your Honor.
Oh, Mr. Fields, did you want to?
Yes, I'd like to move into evidence OPC Exhibit 5 and 6. I'm sorry, that's wrong. OPC Exhibit 6 and 7.
We didn't mark Exhibit 7.
Okay. Exhibit 7 would be the response to staff data response 24-3.
Okay.
Like that marked, there's OPC Exhibit 7.
That was the one I didn't have. I had 6, but I didn't have 7.
What?
Another
Yeah.
So I'd like to move OPC Exhibit 6 and 7, please.
Seeing no objections, they are admitted.
Thank you, Your Honor.
Mr. Spivak.
Okay. Good afternoon, Mr. Valdez.
Good afternoon.
We're going to work from your rebuttal testimony.
Okay.
And let's start at page 2, please.
Okay.
Okay. All right. At line 7 there, you make the point that the equipment PE purchases, as well as affiliate Monpower, is basically the same equipment. So, in other words, your plant in Maryland is essentially the same equipment that you use in West Virginia. Is that correct?
Yeah, the poles, transformers, wire, there's nothing unique about Maryland that would require us to buy a different transformer than it would in West Virginia, for example.
Okay. The next question, you start out, you refer to that settlement you were just talking about with Mr. Fields.
Yes.
Why in the settlement do you agree not to? Did you agree not to use the depreciation rates? Who was it, or what? Did some party find it objectionable in some way or other?
There were multiple. Oh, I'm sorry. Were you done?
More or less.
There were multiple parties in the West Virginia base rate case. Some parties wanted to use it. Some parties didn't. And in settlement, in order to achieve what we thought was reasonable and what the other parties thought was reasonable, one of the items that we gave on was to not use the depreciation rates. We certainly supported them, or else we would not have proposed them to begin with, but we agreed not to use those depreciation rates, which ultimately ended up in a higher depreciation expense for the distribution assets.
That's kind of where I want to go with this. Now, based on what you said about the rates here, use of that West Virginia study, the rates as a proxy for rates here would result in reduced depreciation expense. Is that right?
That's correct.
And was that true in West Virginia at the time as well?
For the distribution assets, that was true.
And yet the company was supporting that, the use of that
It was
study?
it was supporting, because the one item I want to point out, as I mentioned before, just remember that West Virginia is vertically integrated, and so a depreciation study included more than just distribution. It was distribution, transmission, and generation, because all three aspects get evaluated together within West Virginia. The distribution had a small decrease in the expense. Transmission, I'm not sure exactly where transmission ended up, but generation had an increase. And so the net sum of those was an overall increase in depreciation expense.
All right, so now for your next question and answer, you note specifically that the use of the West Virginia study would reduce Maryland, and the rates therein would reduce Maryland depreciation expense by $2.7 million. Is that correct?
That's correct.
Okay. And the existing Maryland depreciation rates date back to this study done in the 1980s. Is that also correct? Or was it early 1990s?
93, I believe, was the evaluation year.
Okay. And you don't present in this case any evidence that the older Maryland depreciation study is a better fit for your Maryland plant than the 2014 West Virginia study would be, do you?
I'm not suggesting that. I find it curious that we go from 1994, depreciation expense is at one level, and then you take a look at it about 10 years later, depreciation expense goes up. And then you take a look at it several years later, and then depreciation goes down. And so it looks like Maryland is right now right about the middle between where West Virginia had floated between those two levels. I'm not saying to use the existing level of Potomac Edison, West Virginia depreciation rates. What I thought I needed to include that, or else it was an incomplete data set.
Thank you. All right. Okay, can we go to page 6, please, of your rebuttal testimony?
Okay.
Now, you make the point that the service lives of Mr. Garin are beyond the upper end of the typical industry range.
What I'm talking about there, I'm actually referencing Mr. Spanos' testimony when he talks about the industry range.
Okay, and you have a table below that gives the OPC depreciation rate and the time it would take using that rate to fully depreciate a plant item. Is that correct?
That's correct. It's simply by taking the inverse of the depreciation rates.
Okay. I was going to ask for each of the items in the table. Do you know what the typical industry range is, or do you have the typical industry range?
I don't know that off the top of my head. That is in Mr. Spanos' rebuttal testimony, though.
Look for it there, then. Thank you. Can we go to page 9, please?
Okay.
And you make the point that having solid investment grade ratings is necessary. Has First Energy's bankruptcy not affected PE's credit rating at all?
There's
in
been
a negative manner?
Well, to clarify, First Energy did not do any type of bankruptcy. That's the unregulated affiliate, First Energy Solutions, I believe, and that has no effect on Potomac Edison.
Okay, thank you. Okay, going further down the page, the last sentence in answer to the next question. Okay, show that OPC's 9% decrease in distribution rates for P is counterintuitive to what actually happened during that period?
Yes, I see that.
Okay. And you're talking about depreciation relative, or electricity prices relative to inflation, is that right?
That's correct.
Okay. But isn't it true that depreciation rates are not actually subject to inflation?
When looking at individual pieces of the rate, yeah, I think you can break apart certain pieces of the rate and say, yes, this is subject to inflation. No, this isn't subject to inflation. We keep on diving down into details. Then, certainly facilities that we buy that make up the plant and service, yes, that's subject to inflation. And whenever you keep on slicing it, you could say that some pieces are, some pieces aren't. But overall, if you take a look at for 25 years, I think you'd find it quite an anomaly that electric utilities rates have not changed at all in the face of inflation.
No, I'm not talking about electric utility rates. I'm talking about depreciation rates. And at heart, they're service lives, are they not?
Excuse me?
At heart, depreciation rates are service lives, are they not?
Well, it's a combination. It's a combination of the service lives as well as the net salvage.
Okay, and the net salvage piece might be subject to some inflationary element or price thing?
That certainly, or cost of removal. To remove a piece of equipment today is going to be different than it costs us 10 years from now to remove that same piece of equipment.
On the other hand, service lives are not measured, don't suffer inflation, do they? They're not affected by price inflation.
Intuitively, I don't think it does, but I would defer to the expert analysis from Mr. Spanos to make sure he can confirm my assumption.
Thank you. Okay, let's turn to page 12, please. And the sentence starting at line 3, at line 2 there. As such, in developing the allocated components, staff believes that P should be removed directly assigned. Sorry. I'm just kind of repeating it for the witnesses. The sentence that starts as such, in developing the allocated component, can you read through that in the next sentence, please?
Read it to myself?
Sure.
Okay.
Okay. Which would result in a change of $5,060,000. Can you explain for us non-accountants how removing $886,000 from this account results in a change of $5 million plus?
I'm not an accountant either, just to let you know. But this goes to these are PE total amounts, and then you take a look at directly assigned amounts, and there is a piece that involves, from what I recall, this goes back to data response. But I did work through the numbers before I put this down to make sure it worked, but I believe that 886, to my recollection, is a capital and O&M component. And then the change that occurs from the $5.06 million to the $5.097 million, I believe that's just the O&M component. And so there's a calculation in the middle that you don't see that results in the difference between those two.
Okay. Now, and you have two figures here. One is a charge to P of $5,060,000. The other is the assignment of $5,097,186 developed by the company. So the first is the result of staff's work, and the second is the company, correct?
That's correct.
And so the difference between staff and PE on this is roughly $37,000, is that right?
Roughly, yes. The basis of that wasn't to point out the magnitude of the difference. The basis was to talk about the directly assigned piece is not buried within the allocated piece. There's a directly assigned piece and there's a separate allocated piece that are separate and distinct from one another, but they're not joined so that one has to be removed from the other.
All right, now let's go to page 15, please.
15?
Yes.
Okay.
And I'm looking at the sentence that starts at line 7, where you state the removal of compound interest and replacement with the company's simple interest calculation decreases staff's adjustment. When people invest in something that pays interest, they usually expect compound interest, do they not?
I've seen, I don't know if it's a fast and firm rule, I've typically seen compounding whenever the investment vehicle is beyond 1 year. If it's shorter than 1 year, then I've seen simple interest.
Okay, and the same is true when a bank makes a loan. They charge compound interest, don't they?
If they make a loan, and if it's short term, I guess that'll be subject to not only what the bank's policies are, but maybe the risk of the customers and what ultimately their different goals are for that. But I think a bank could very well have that 1 year delineation. Something less than 1 year is simple. When you get to multiple years, then you compound it.
Thank you. Okay, top of page 17, please.
Okay.
You state that a corrected deferral amount of $3.13 million is provided in Exhibit REV 29. So, assuming that the Commission requires that the company repay its regulatory liabilities to customers, this is the amount you would recommend, is that correct?
That's correct.
Okay, you have a quote at the top of page 18, talking about the goals of the TCJA.
Yes.
Now, allowing the company to retain a portion of the taxes that customers overpay the company isn't consistent with the goals of the TCJA either, is it?
Well, the specific goals, I don't know if the goals of the TCJA go into that level of specificity. And because of that vagueness, that's whenever we originally advocated to retain the entire amount, and of course the Commission had disagreed with us and had us return about $5 million, which we did, and therefore we're thinking that an appropriate balance. It's not as if we abandoned what we thought was reasonable for the retention of it. But perhaps a fairer balance is, since we've already refunded the majority of it, that the remainder we're still advocating for retention by the company.
Okay. Now, you read the Commission's order on this particular subject, did you not? Their
I
original
have.
order?
I did.
And you would agree that they were pretty clear that they wanted any overpaid excess taxes returned to ratepayers, were they not?
What I recall from the order is that, number one, they wanted us to track it, which we certainly did, and we definitely did. And then for the utilities to make a filing, and in that filing for the utility to demonstrate when and how that would go back. And that's precisely what we did, is our filing explained the how, basically, through this filing, and the when would be effective date of new base rates.
You go on to the arguments in that same question and answer. You go on to present the company's reasons for its request to retain those taxes. Is that right?
Generally, yes.
Okay. Now, taxes are normally a pass-through expense for a utility, are they not?
Yeah, I struggle with that term pass-through. I don't think necessarily any component of the company's rates as they exist right now are pass-through. Yes, the amount of the various components that are not capital related, the subject that they're not in dispute, then you could say they're all pass-throughs. To have a how I view pass-through is that there's a tracker mechanism, that to the extent that it changes, then the tracker keeps track of that change and then adjusts rates accordingly, either through a regulatory asset or regulatory liability, and the disposition of that is ultimately determined by the Commission. That's how I'm viewing things as a pass-through, because that is the way to determine the exact value.
Let's go from a slightly different angle. Okay, your expense items and the money you collect to pay them are all grossed up for taxes, are they not?
Or expense items?
Yes. Really, all the revenue.
Expense is normally deductible for tax purposes, so we would not gross up our expense.
The revenue you collect is generally grossed up for taxes, correct?
The portion of the revenue that's not deductible for tax purposes would be grossed up for taxes.
Okay. And there is no expectation when that money is paid to the company by customers that the company will retain it. The expectation is that that money will go to the IRS. Is that not correct?
I don't know what the expectation of the customers is, if that's what you're asking me.
The regulatory expectation.
Oh, the regulatory expectation. I don't know. I guess I can't speak towards the expectation. I can say on a practical aspect that in our rates, things change all the time. They're always moving up and down.
Do you know of any authority that would expect the company to retain the money that's paid for taxes beyond that you are given to pay your taxes beyond what would be deferred income taxes?
Well, it's curious you mentioned that, because a similar type incident or discussion came up in our West Virginia tax filing, because we had to do a West Virginia tax filing. Now, we didn't have to file a base rate case because we had a very recent base rate case in West Virginia, so that was the basis for determining it. There was no decision yet regarding that. So they call it a stub period. We call it an interim period. So the period from January 1 through August 31st of last year, is still sitting as a regulatory liability on the company's books. The ultimate disposition of that won't be determined until a filing as late as 2020, because the West Virginia Commission, we couldn't get to a full determination of exactly what to do with that. So what we did in that proceeding was we changed rates effective September 1 of 2018, and that regulatory liability is to be determined at a future date.
Does the company normally expect to retain the money that it is given as part of a gross up in its own accounts, or does it expect to pay its taxes?
The company has to pay its taxes.
It has to pay its taxes, and that money is provided to the company by customers for the purpose of paying those taxes, correct?
The taxes will be a function of whatever our taxable income is for any one particular year. I don't know how I can break it down into individual pieces, but whatever the taxable income is for any particular year, that is the taxes that we will pay.
And you are given a certain amount of money from customers to enable you to do that, correct?
We're given a revenue requirement and certainly an opportunity to earn. I shouldn't say earn, but in order to collect enough revenues, presumably we will collect enough revenues, but regardless of whatever that level of revenue collection is, we will pay our taxes.
Okay. Can we turn to page 20?
Okay.
You make a point beginning in the answer at line 12, discussing allocation. Staff witness McAuliffe you point out staff witness McAuliffe's critique of P's allocation process for step 1. I note that you don't claim that what staff's done is inconsistent with what the Commission has recently done in rate cases, do you?
Yeah, I guess what I'm trying to say in my rebuttal, and maybe it's not coming clearly enough, and I'm afraid to some extent maybe myself and staff witness McCullough are maybe talking past one another, that he has a methodology and I have a methodology, and I'm not saying one is necessarily superior to the other. All that I'm saying is that I did not, especially when I get down to allocations, and this is common to exactly what I do in West Virginia too. I don't get a formula and just plug a number into it regardless of the outcome. I take a look at not only what those allocations are, ultimately what the end result is to the customer, and then I have to take that a step further. Not only is it determining what the rates are, is there customer movement between rate schedules? Because if there's a substantial shift in what one customer group, what rate schedule gets charged versus the other, there is going to be a migration of customers from one rate schedule to another, so that we'd have to impute then lost revenues as a result of that. And that actually happened in our 2009 base rate case in West Virginia, is that due to an allocation process, it made an entire rate schedule obsolete. Everybody moved off that rate schedule onto a new rate schedule. And that's my concern, is to not, through the allocation and rate design process, to functionally make an entire rate class disappear.
Okay. On that subject, on page 22 of your rebuttal testimony,
Yes.
beginning at line 15 with that sentence, you make the point that a tighter bandwidth around unity, that alternative methodologies can yield a tighter bandwidth around unity, a unity indexed ROR, with more movement for under-earning rate schedules of R, PH, and AGS, as well as the over-earning rate schedules of G, C, and H and F. Do you see that?
I do.
Okay. And by this you actually mean a faster or less gradual approach to unity, is that correct?
Yeah, I guess what I'm trying to explain in there, if you take a look at the staff resultant index RR, I'm taking a look at the extremes to start with, that I see a low of 0.46 and then a high of 1.85. And that's why whenever I took a look at an alternative, and I'm not necessarily advocating the alternative, I'm just trying to illustrate a point that once you move away from something purely formulaic, you can get a little bit different results. It got a little bit tighter. The 0.46 is now, it inched a little closer. It's at 0.57, and my highest value is no longer 1.85. It is 1.63, so it gets a little bit narrower. Now, I do acknowledge that it doesn't have the same level of movement for other rate schedules, but then that gets to the other parameter, that then you start maybe tweaking the second process, the second step. And then after you do that, you can't step back and then say you're done. Then you got to take a look at customer migration between rate schedule, and is everything that was done there, what is the end result? Is there going to be basically a massive migration of customers from one rate schedule to another to ultimately make one rate schedule obsolete, which was not the intent of what I was trying to do in the rate design. And I'm not suggesting that Mr. McCullough was intending that either. What I'm saying is that that's the entire process involved in not only looking at just the index ROR, it goes actually beyond that, multiple steps.
Okay, let me take you back to just where you went with the making a rate class obsolete and causing a mass migration. I mean, in most cases, customers are not able to migrate from rate class because they fall within a defined rate class, do they not?
That's not the case for Potomac Edison's rate schedules. When I say Potomac Edison, historically for what would have been the Allegheny Power companies, Potomac Edison, Monongahela Power, and West Penn, it didn't segregate customers to just one option. There's always a general service rate schedule, which everybody is eligible for, regardless of size, regardless of service voltage. Everybody is eligible for that. And then depending dependent upon size, then there's different eligibilities, and the larger and larger go into different categories. But the very largest customer, what would be on our rate schedule PP for primary power, they can be served on rate schedule G if they so wish. They're not going to, but they're fully eligible to do that. And if something happens on rate schedule PP that causes rate PP to be unadvantageous for that customer, then that customer is freely able to move down in rate schedules and freely able to take rate service on rate schedule G. So that may be somewhat unique for Potomac Edison's as compared to other utilities in Maryland, but that's standard practice for Potomac Edison as well as Monongahela Power.
That actually is something I've never really heard from any other utility. Asking that, would that be true of residential customers as well? They take service under Schedule G?
No, residential service is limited to residential customers at single-phase service.
And likewise, they don't have the option of any other rate class?
No.
Okay, next page, page 23, we have a discussion of rate impacts.
Okay.
Okay, and you're discussing the use of bill impacts versus total bill impacts versus distribution rate impacts, is that right?
That's correct.
Okay. Now, would you say, roughly speaking, that supply costs have generally been on a downward trend over the last decade or so, have they not? There have been blips upward, but mostly down.
I'm basing upon, I need to be tread carefully because of the bids that are received in standard offer service, but I can speak in terms of West Virginia. So I'll tread carefully by talking about West Virginia, because West Virginia, even though we own generation, we access the market. And just to explain why is we take all of our generation, we sell it into PJM, and we turn around and buy the generation back for our customers. So inherently, within that entire transaction, it's taking a look at where the market is. And in West Virginia, several years ago, the market was more on a depressed stage, and West Virginia is applicable to Potomac Edison, Maryland. It's not applicable to the other utilities because the zone, the transmission zone, is the APS zone, and it's identical for Monongahela Power as well as Potomac Edison. So the price of electricity at the far western edge of Monongahela Power, close to the Kentucky border, is the exact same price for electricity in Frederick, which is the far eastern edge of Potomac Edison. It was taking a downward trend. Market prices are moving up, and that they've been moving up recently within the APS zone. Markedly so much is we recently had, as of January 1 of this year, a $75 million decrease for our customers in West Virginia. And it's a strange situation, but as market prices go up, rates go down in West Virginia. Because the more prices go up, the more that we get in terms of value for our generation, and that value gets passed directly on to customers. So the $75 million decrease that went into effect not even a month ago is a result of those increasing market prices. And when taking a look at our filing, which was based upon rates effective this year, there was nothing in the market prices that indicated downward trend that would cause us to need to hold back any of that $75 million. So it was, we presented our evidence last year as to the rates should go down by $75 million. The parties looked at it and audited it and said, yes, the company's correct, that it's it's strange for a utility in West Virginia to come in for a $75 million decrease, and even the chairman, when he came into the hearing, said this is probably one of the most unique situations he's run into. But upon evaluation of the evidence, they agreed that because of that, because of what's happening with market prices and our interaction with our generation facilities, that the market price is trending upward, at least in the APS zone.
Okay, so any increase you get here is going to be on top of that upward trend in SOS market prices, correct?
Yeah, to the extent, I mean, I did see what the bids were from last week, so I know what the resultant SOS rates are, at least that will be proposed. And actually, we filed them, I believe, today for Type 2 effective March 1 and for residential effective June 1 of this year. And so I do know the movement in the market prices as compared to the prior auctions. It's probably a little bit easier to see on residential because residential is done on a laddered stage, and you can see the earlier market prices and the progression of the market prices into the build up of the total SOS rate.
So, which way are the prices that you filed today? Which way are they? Are they an increase or a decrease over what's?
I can't recall. There's been a strange anomaly in the residential SOS rates where the summer period is lower than the non-summer period, and that's been the case for the past few years. I can't explain that. That's the result of the bidders. If I take a look at it requires a little bit more analysis than just taking a look at the absolute change in the rate, because it's not the change in the rate from non-summer to summer. It's kind of an aggregate of overall of how that rate is moving, because by changing in seasons you could get a change in the price that's not necessarily reflective of what the market is. Just, it's a difficult question for me to answer sitting here without doing additional analysis.
Okay, thank you. All right, let's go to the bottom of page 24, please. Okay, you note staff's assertion that increases to customer charges are directly counter to Commission goals to encourage energy conservation and allow customers greater control of their bills.
I'm sorry, where was this again?
Bottom of page 24.
Bottom of page 24. Okay, and in what line again? I'm sorry?
19.
19. Okay.
Okay. And you are aware that the Commission has specifically emphasized the importance of those goals?
This is the quandary that I'm in. My trade and my education background is an engineer. And so when I take a look at things, it's as an electrical engineer, and then I take a look at the facilities, and on an engineering basis, and in probably the quarter of a century of experience within rates, I have difficulty putting forth something that doesn't follow the actual facilities or the cost causation. I would actually have a difficult time in justifying it on an energy rate rather than, say, a customer charge or a demand charge. And I understand that the Commission may have different viewpoints, and I understand their concerns. I don't have a basis, though, to support that through testimony.
Okay. Can we go to page 25? And you have a table 5 where you give the various customer charges.
Yes.
And your proposed residential customer charge is $7.70. Is that right?
Yeah, that's correct.
Now, you are not claiming that this $7.70 will pay all of the residential classes' fixed costs, are you?
No, I'm not making that assertion. What I tied that to, there's an exhibit REV 15, that shows the O&M component associated with services and meters, and essentially like a revenue requirement for the capital associated with those, and the summation of those is what this dollar figure represents. It is not intended to represent all the fixed cost.
Okay, let's go to page 28. And the question and answer talking about the purpose surcharge.
Yes.
And you take note of a recent decrease in that surcharge?
Yeah, it was late November, we made a filing for the commission. There were two filings. Their annual periodic filings were required to make. One was the purpose surcharge, the Warrior Run purpose surcharge. Warrior Run PURPA, P-U-R-P-A. One was the Warrior Run purpose surcharge, and the second one was an Empower surcharge. Both had decreases. The Warrior Run purpose surcharge was about a $15 million decrease, and the Empower surcharge was about a $3 million decrease. So in total, it was our filings at the end of November was about an $18 million decrease. And those were approved by the commission. It was just before Christmas, so they went into service. Those rates went into effect on January 1 of this year.
Now, the purpose surcharge could increase again this June or this coming December, could it not?
It could.
Okay. And to the extent that this happens, that could reduce or eliminate the mitigation that we would now get from the recent decrease, correct?
Yes, and that's not the point. Maybe the point was getting lost on what I was trying to say. To the extent that there was a concern about rate shock due to the rates changing as a result of this proceeding, that's already being helped by mitigation through the Warrior Run purpose surcharge, and even though I didn't mention it, it's the Empower surcharge as well, that's going to offset the change associated with these rates. Now, as you mentioned, Warrior Run, PURPA, and Empower can change in the future, but that's no different than it's been for the past, for the purpose surcharge since 2000, and for Empower, I think, since 2010. So that's the same process that has existed regarding any type of rate shock associated with those surcharges.
Okay, thank you. Let's look at page 30, please.
Okay.
Okay, now you are talking about Schedule C and the fact that you have a higher rate for Schedule C because it's grandfathered.
Yeah, Schedule C, if I am going off recollection, I believe that was closed in 1991.
It's been grandfathered for quite a while now, then.
It has been, and the reason why Schedule C was closed and Schedule G was created was Schedule C is a bit confusing for the customer to understand. It's a 3 kilowatt hour, and this is granted, this is a legacy structure from whenever Potomac Edison owned generation, so there were reasons behind that. And what happened at that time was it was a declining block in terms of rates, and the second block changed with the amount of the customer's demand. So there was a demand charge, it was just buried within the energy charge, and it was really hard for customers to, number one, understand the formula, and two, to see what their demand component was. So Schedule G was created, and instead of burying the demand component within the second block, it made an explicit demand charge and explicit energy charge. They were separate and distinct, and they made it very clear for the customer. Therefore, as you mentioned, Schedule C was closed to new customers. Now, we didn't, whatever the reasoning was, I don't know, but Schedule C was just closed. Its companion schedule, Schedule G, was opened, and they were essentially the same schedule.
Okay, let me stop you there. That's far more explanation than needed. The point you seem to be making here is that the commission approved this higher than schedule, the higher rate in the grandfathered class in numerous cases. Is that a fair summary?
Yeah, the original determination, I read this in testimony, this was in the 1994 case. It was the commission's encouragement, or I'm not sure if it's encouragement or directive, but it was to try and incent customers to move off of Schedule C to Schedule G through a slight difference between those two. And so we've carried that forward through not just the distribution aspect, but through other aspects of the changes associated with Schedule C.
And you say, and you then go on to say that this was approved by the Commission 61 times in case numbers 8908, 9056, and 9064. All of those are SOS related, are they not?
They are.
Okay. And you don't claim that in any of these cases the supply rates for Schedule C were increased by anything in excess of what the supply cost increase that actually occurred was, do you?
Oh, yeah, absolutely not, because the supply cost for that is determined for those schedules in aggregate as well as other schedules, and so the cost from the bidders is allocated or separated to these individual rate schedules. That's where the rate design comes in, because we don't bid out Schedule C separately from Schedule G.
Right. And in none of those cases did the issue ever actually come up whether one might regard that higher rate in Schedule C as in some respect punitive or as an incentive to get people to move to Schedule G.
I don't know of that issue ever being brought up.
Okay. All right, bottom of page 31, you have a quote, and particularly at the bottom of that, the quote in general addresses declining rate blocks. You see that?
I do. That's a quote from my direct testimony.
And the last full sentence on the page there, in addition, declining rate blocks makes little sense for a distribution utility, since PE's fixed costs do not decrease with increased electricity consumption. See that?
I do.
Okay. And do you think this is in part because declining rate blocks encourage greater energy use, or at least fail to discourage it?
That's driven more so by the reason why declining rate blocks were created to begin with, and it had to do with whenever Potomac Edison owned generation assets. Now that Potomac Edison obviously divested from any generation that it has, that type of generation item makes little sense on a distribution rate.
Okay. And in fact, nobody is objecting to the elimination of declining rate blocks, are they?
No one has objected to that. I agree.
Okay, the next page, page 32. Sentence beginning at line 11.
Okay.
Attempting to associate such costs with kilowatt-hour consumption is contrary to causation, and there you're referring to customer costs or demand?
What I'm referring to is if you take a look at the jurisdictional class cost of service, or the cost of service, I guess not the jurisdictional, the class cost of service study. And it doesn't matter which one you look at, whether it's staff's or the company's. If you take a look at the individual items and you ask yourself which one of these costs change as customers' energy use increases or decrease, you'd be hard pressed to find any of them that do. The problem is that the majority of the rates, and when I say the majority for residential, because residential is a vast majority of our customers, the kilowatt hour rate is a proxy for the collection of a demand-related cost or other type of costs. And I'm not suggesting a change in that. What I'm working towards is for these larger, more sophisticated customers that whenever they ask me about these rates and why would something, they're a bit more sophisticated, they look outside and they ask me what part of that substation or what part of this pole changes the more or less electricity that I use, then it's hard pressed to give an answer regarding that.
Okay, but this proxy use of volumetric charges to cover all parts of residential rates. That's what's been done since the rates were conceived, has it not?
Yeah, I think that's a function of the infrastructure. Infrastructure is a little bit different for other utilities now. We don't have AMI or smart metering, so we couldn't do anything other than a customer charge and a kilowatt hour charge.
It might also be a function of policy.
It could be a determination or a function of policy as well.
Okay, can we go to page 35 and look at table 6?
Okay.
Okay. And you are comparing the average monthly charges under P's proposed rate design versus staff's rate design. Is that a fair characterization of the table?
Yes, that is.
Okay. Now, looking down through the table, in most of these cases, it seems that the large customers would experience lesser rate increases or rate decreases under the company's proposal to eliminate energy charges for those classes. Is that how it looks to you?
Yeah, because that follows the cost causation, and what I'm trying to do is not send the wrong signal to the customer. These customers, for example, the industrial customers, I don't want to send a signal that 3-shift operations are bad. You should go to 1-shift operation. I think it's better for the economy for these industrial customers to have an incentive that using 3 shifts, having more employees, having a benefit to the economy, as well as tying that to cost causation, works for them. Now, it's just one piece of the bill. It's distribution.
Do you have any evidence that that this difference we're talking about here is going to make any difference in how companies parse out their shift work?
I don't have any evidence of shift work. I do have firsthand experience dealing with industrial customers, especially since for 6 years of my career, I worked directly with these exact same type of customers I worked with.
Okay, now, to the extent that these companies' proposal would result in those lesser rate increases or even rate decreases for these larger customers, the company is going to receive less revenue from these classes, is it not?
I'm sorry, what was that a question again?
To the extent that the company use of the company's rate design will in fact result in lesser rate increases or even rate decreases for these larger customers, the company is going to receive less revenue from those rate classes, correct?
Only if in aggregate, if you take all the customers, add them together, and only if that's a decrease, there's going to be increases and decreases. And if you notice from the chart, they're tied.
I'm thinking less revenue as compared to staff's proposal.
The allocation that we didn't have any increase allocated to these customers because their index rate of return was so high. So therefore, the net for us, the company's proposal, is 0. There's no change in revenues, whereas I think there's a small change in revenues based upon staff's proposal.
Okay. So to the extent that difference exists, under the company's proposal, other classes are going to have to make up for that revenue. Is that right?
Well, what I would say is that if an increase is allocated Schedule PP, then I'd still advocate for a demand rate. It's just the demand rate that I'm advocating for would be a little bit higher to make up for that, whatever that dollar amount is that's in staff's proposal.
Mr. Spivak, we're going to need to take a break soon. Are you just about finished? Or?
I am very close to done here.
Okay.
I think I have about 4 more questions.
Okay.
I think about
Thank you.
5. Okay, going to page 38. Okay. And the sentence at lines 14 through 17. Schedule COG is certainly one area that needs to be updated by replacing payments based on the cost of generation for PE's prior ownership of generation. You see that sentence?
I do.
Okay. Now, am I wrong in saying that this is essentially updating the avoided cost calculation?
I'd say that's a correct high-level summary that this updates the avoided cost. I agree.
Okay, thank you. Okay, on the next page, 39, the very first sentence answering the question is Schedule SP is not a separate rate class.
Mhm.
It doesn't apply to anyone but generators, does it?
It doesn't apply to any what?
Anyone but generators, does it?
Yeah, anyone but wholesale generators on the PGM system that happen to be within the PE Maryland footprint.
Okay, page 40.
Okay.
Okay. You make the point that the standard delivery time for U.S. Postal Service between Maryland and Ohio is 3 days, so the company's proposal of 5 days is greater than the standard from the USPS.
Mm-hmm.
Okay, so assuming that the U.S. Postal Service is on time, this means that a customer has to mail their payment at least 3 days before the 5 days, does it not?
It would be 3 days before the 5 days would be 2 days after the due date. Does that make sense?
Yes, it
Okay.
actually does, because we're talking 5 days after the due date.
Okay.
So it has. They have basically a grace period of 2 days.
They
there.
do. That's correct.
Okay. And it leaves the determination of whether a payment is late or not up to the vagaries of the U.S. Postal Service delivery, though, doesn't it?
Yeah, and that's why we did not put it at 3 days. There's no buffer allowed, and so we put that at 5 days. This is a practice that First Energy has at of 8 of its 10 operating companies. The only 2 that don't have this is Potomac Edison and Monongahela Power.
Have you ever heard of the mailbox rule, Mr. Valdez?
I have not.
Would it surprise you to know that there is a legal principle that a payment is generally considered made when it is dropped in the mailbox?
I guess I couldn't speak to it one way or the other. I'm sorry.
Okay. Thank you. I think I will leave it at that.
Thank you very much, Mr. Spivak. Do you have to redirect, Mr.
No,
Gunderson?
Your Honor.
You don't have any redirect?
No.
Okay. Well, since there's no redirect, we will adjourn for 10 minutes, and we'll try to finish with Mr. Valdez today. And I suspect we probably won't get to Mr. Pavlovic today. And sorry about that, Mr. Pavlovic. We're adjourned. Okay, we're back on the record. Good afternoon, Mr.
Good afternoon.
Valdez. Thank you for being here.
Thank you.
Mr. Valdez, I do have a number of questions, and I'm going to ask you to try to answer them, but also, be brief given the hour. So, if you would try to be as brief as you can, I would appreciate that.
Absolutely.
I believe you said in your testimony that PE Maryland spends about 60 to 70 million annually on reliability. Did I read that right?
It's historically 60 on capital, not just reliability, and forecasted to be 70.
So it's capital.
It's total capital.
It's total capital, not just reliability is 60, and 70 is.
70 is the forecast. So
forecast.
it's just a difference between historical and forecast. That's it.
Right. So you expect us to spend 10 million more, 1/6 more,
Yes.
for, each year, 1 million, or is 70 the number?
There was a bump up in the supplemental information that we filed shortly after we filed our case. It was in there. I can't recall exactly what was driving that bump up, but there was an increase of about 10 million from historic, so I thought I should point that out.
Right. And is that then you expect that bump up is going to stay? So you're looking to.
At least according to the forecast, it would go up and then stay.
Okay. Do you have an idea of how much solar penetration you have in Maryland, residential solar?
I unfortunately do not. I know it's much higher than we have in West Virginia, but I don't know the solar penetration. I'm sorry.
Okay, thank you. So on your incentive compensation, its commission precedent has been to allow safety and reliability, but not the financial metrics with incentive compensation. Are you aware of that precedent?
That's my understanding.
Right. And has the company separated out the safety and reliability from the financial components of the incentive plan?
We did not. I do recall it. I believe it was in staff's testimony. Maybe witness Poboreski. I think she may have separated it out, but I know it's in staff's testimony.
Right. And do you agree with that separation?
I didn't specifically take a look at that. I'd have to go back and take a look at that separation to ensure that we agree that the separation between those two is valid and reasonable.
Okay. Let's see. Those are some deferred questions.
Okay.
Now we'll move to your list. So with respect to the storm adjustment, using the deferral accounting, so how is that going to work? Is it going to be, I'll just pick a number, $1 million a year in rates, and then at the end of a year you're going to do an annual reconciliation, and if it was only $500,000, what would be the amount going forward the next year?
It would accrue. Each year let's say it was a 500,000 under collection.
Right.
Then it would be an asset that year. And let's say the subsequent year was a 500,000 over collection. That's a liability. They would both net out to zero. And so after 2 years, that deferral is now effectively zero. So it's just going to build up over time.
Well, so you're saying that it's just going to, the deferral's going to change over time, right?
Yeah, it will be a
Okay.
cumulative
Cumulative
deferral.
deferral.
That's correct.
Right. And would that occur until the next rate case, or would there, when would the reconciliation be performed?
Well, the proposal is to accumulate that asset or liability, and then in the next rate case present that to the commission. And I would expect, there's multiple ways to do that. It could either be done as a surcharge, or you can do the traditional method and amortize it over a fixed period of time and put that as a component within the distribution rate.
And do you have a sense as to when the next rate case might be filed?
Well, in response to the question previously, it won't be 25 years from now. It'll definitely be before then. We look at it all the time. I would say rate cases will be much more frequent than they have in the past for us. And to give you a parameter, in West Virginia, in the past 12 years, we filed 3 rate cases.
Okay. So we would just have to wait, under your proposal, we would just have to wait for the reconciliation till the next rate case. But Is that right?
Yeah, that's the proposal, although it would be open to different avenues.
And staff had a different idea. Is that right?
They essentially had the same idea. They didn't want the additional adder for the historical 5-year average to be added, but they agreed with the concept. So they agreed with us, but they wanted to have basically a carrying charge of that added to that, and that was agreeable to us.
Mm-hmm. Okay. So, very briefly, when I'd like to talk about cost allocation, just standard cost allocation. Let's just say your time.
Okay.
You know, today, the last 2 days, you've been here in Maryland. Do you direct charge that time?
I do. I have to fill out a timesheet. Every 2 weeks I fill out a timesheet, as well as my employees, as well as other people within the service company. And then there's time spent for this rate case, for example, is charged directly to the rate case. Now, it's not recoverable, but what it's done is it's tracked within the time devoted for the rate case, and then something for some other special project, that's specially done as well. If it's just general use, then it goes through a standard allocator that separates our time between West Virginia and Maryland.
Right, and that's set forth in the CAM.
That's correct.
Okay. So, with respect to the surcharge, the EDIS, are you proposing the EDIS to address regulatory lag?
No, it's not to address regulatory lag. I mentioned as one of the 3 components. That's one of the resultant effects of that. The real thing was, right now as it's proposed, they're proposed dollars, and wouldn't think that on a surcharge it'd be appropriate to do things on proposed. We want to do it on known and measurable, and that's really the whole purpose, is that whatever the commission were to approve, then we put that in front of the commission as to this is what we actually spent, and allows them an annual review of that, and then the surcharge also has commensurate recovery of that.
Okay. Are you aware that the commission has rejected surcharge components of surcharges when it's all O&M, such as vegetation management?
Components of surcharge?
Well, like the vegetation management, that's all O&M, is that right?
It's actually 2 pieces. There's one piece that's O&M and a second piece that's capital.
Really? What's capital on vegetation management?
It follows the accounting rules, but I think the capitalization of it has to do with items that are beyond the traditional maintenance, maybe clearing the floors. I think if it's removing danger trees, I think that falls under, if I'm recalling from accounting, I think that falls under a capitalized item.
How much of the surcharge is capital, the proposed vegetation management surcharge is capital versus O&M?
It's in my Exhibit REV 23. I think it should be the very first page on Exhibit REV 23. I'll give you a minute to get there.
Thank you.
Yeah, 23, page 1.
Yep.
There's a line under vegetation management called incremental capital and incremental O&M, and there are the annual amounts. The capital is about a little over $1 million, and the incremental O&M is $2 to $3 million.
Where are you looking? What
Oh, I'm sorry.
line are you on?
There.
Okay.
Okay.
Incremental capital, incremental O&M.
Yes.
Okay, thank you. So, Mr. Efron proposes a capital repairs adjustment. Are you familiar with that?
I'm somewhat familiar with that. I do rely upon Jeff Adams for that.
All right. Well, he quantified that at 26.4%. Does the company have a different number that it proposed?
It doesn't. This is from my understanding that we don't have a different number because there's no known and measurable number. We actually won't know if there is a number greater than 0 until we do our tax returns.
Mm-hmm. Okay. So also, Mr. Efron's SIR rebuttal on page 12 says that the correct number for the Tax Cuts and Jobs Act regulatory liability is $3,244,000. That's different than the $3.13 million that you had earlier. Do you continue to assert that that your number is the correct one, or has Mr. Efron made an adjustment that you think is correct.
That's a pretty easy explanation. My number's the correct number because what Mr. Efron did was he took the 5-year average of 2019 for ARAM, 2019 through 2024. He took that and applied that to 2018. So he took the wrong year, and he took a historical year and applied it to 2018 rather than applying the 2018 year to 2018.
Okay, thank you. So you said earlier in your testimony, I think when you were talking with Mr. Fields, that it would be appropriate at times to look at peer utilities for, look to them for treatment and I think it was with respect to earnings. Is that what was that your testimony?
I'm sorry, what part of that?
I think it was, with respect to earning an authorized return. You're saying, well, look at the other companies at 836, we're not even earning there, right?
I'm sorry, yes. When we were looking at trying to determine what the returns would be if we had retained some or a portion, it didn't just look at the 11.9. I also took a look at BGE, Pepco, and Delmarva as far as what their returns were as well, because theirs are certainly lower than 11.9.
Right. And, if it's appropriate to look at the peer utilities with respect to what you were doing there, is it appropriate to look to them for other, to say, well, this is what's happening with other utilities in other areas, like SERP, for example?
Well, the reason why I looked at the peer utilities just for that item is because I thought there would be criticism if I just looked at it just at the 11.9 ROE. And therefore, I needed to get some basis of what the other ones had to try and deflect some of what that criticism is, because I think they're pretty easy criticism. That's the specific reason why I chose those peer utilities, was because of the 11.9 ROE that's currently authorized.
Okay. So I'm going to try very briefly to get into depreciation. I think we've covered that quite a bit. So how long do you think it would take for you to come in with a rate case with a completed depreciation study, accounting for ARAM and all the other variables you described? What would that time frame be?
It's difficult for me to quantify. I have concerns with getting a full depreciation study done within just 1 year for how I've laid out for Mr. Fields. To layer in a base rate case on top of that is where I get concerns regarding that. It's difficult for me to guess.
Okay, do you think it's going to take you 2 years, 5 years? I'd like a time that you think it would be, when you think you could do both of those.
Well, occasionally I get this question from the West Virginia Commission. They say about what's the time frame between rate cases, and the standard time frame, I'd say, is maybe about 4 to 5 years.
Well, I'm not asking for the time frame between rate cases. I'm asking how much time does it take to prepare a rate case, including a depreciation study that takes into account all the other factors that you mentioned, take more time than a year? It can't be 4 years.
No, okay. I'm hazard a guess at maybe 2 years. I don't know.
2 years.
Yeah, I don't. It all depends upon all different studies, because it's one thing to do a depreciation study and then prepare a case, but then there's all these other ancillary class cost of service studies, which until I get into the details, I simply don't know.
So in your view, does Potomac Edison, Maryland receive adequate resources to meet the needs of the Maryland Commission?
I'm sorry, I don't know what you mean.
From First Energy, do you receive adequate resources, from First Energy to meet your regulatory requirements in Maryland?
I think generally so.
Okay. And does First Energy have, I assume if you were to do a depreciation study and have to compile data, there might be some assistance from other entities in PE, is that right?
There could be, depending upon their availability as well.
Right. And have you started a depreciation study for Maryland?
No, we have not.
Okay. When you filed on February 15th, did you know how long it would take to perform a depreciation study?
I knew how long it would take us based upon what was done in West Virginia. I knew it was close to a year. from start to finish in West Virginia. I didn't know what type of additional parameters would be needed in Maryland, and as we further got into the rate case, that caused additional concern for me in Maryland.
Okay. And did the commission require or order PE to file a rate case?
In the 2014 case?
No. Was associated with the TCJA? Was there a requirement that PE file a rate case?
No, there was no requirement to file
Okay.
that.
So it was PE's choice to file, and to say it was going to file when it was going to file. Is that right?
That's correct.
Right. And you knew at that time then that you wouldn't be able to do a depreciation study or any of the other studies with respect to the jurisdictional allocations as well. Is that right?
If we determined through a reasonable check that the depreciation expense was way out of line, I think the probably decision is to inform the commission that our early estimate to do it in the third quarter just wasn't going to work because we needed more time for a depreciation study.
So that would have been an option, that you could have written a letter to the commission to say, we thought we were able to do it, but we're not able to do it.
Right.
That's an option. That
Yeah,
would
I
have
think
been
that would be
before
one
you.
possible option.
Okay.
I-
And when you said that you looked at the reasonableness of the depreciation rate and it fell into the zone of reasonableness, I understand that that's something that you would consider, but is it up to the commission to determine a reasonable depreciation rate?
Oh, yeah, I would think that everything that the company puts forth and its filing would be up to the commission to determine.
Okay. That's all I had. Thank you very much, Mr. Valdez. Mr. Richards?
Thank you, and thank you for your testimony today, Mr. Valdez.
Thank you.
I don't really have that much, if anything, really to add after Commissioner Herman, and I thought the council did a pretty good job today. I did just want to go back again on this depreciation issue. You make the point on page 10 about, optimally, I'll just kind of paraphrase, depreciation studies should closely correspond to the time of a rate case.
Mhm.
And so, and on page 5, you talk about, well, you did perform, or you, for I guess, what was the word you used? A litmus test.
Mhm.
Looked at the two West Virginia companies, and that they had, at least within much more recent than 25 years, had done depreciation studies, and so you attempted to
Yes.
do it at least, this litmus test to see if what you were calculating for PE was within the range of reasonableness.
Mhm.
But it still seems, when I look at the table on page, page 5, that it actually seems to indicate that when you do an updated study, both in the case of PE West Virginia and I cannot say that, where
Monongahela Power.
Monongahela, okay, Power. But in both circumstances, it shows that there is, in fact, a decrease in the depreciation expenses that resulted after, compared to existing. And so, while you characterize it as maybe not that significant, it is notable, isn't it, that they do decrease, and neither one of those use the future value methodology that we do, in fact. Maybe we're the only state that it does do that, but you're in that state right now. So that would indicate, wouldn't it, that if we were to look at these two actual depreciation studies, and on top of that, use the methodology, future value methodology, that we are likely to see a decrease in depreciation expenses. I mean, would you agree?
The part that I don't know is the up and down nature that PE's depreciation expense for West Virginia would have gone up, and then it would have gone down. And the thing I don't know is, you do a new updated study, if the results is going to go up or if it's going to go down. That's the part I don't know, and that's why I took a look at these various data
Well,
points.
didn't the most recent, as you call it, update studies show in both cases, if you just compare their, what you call existing, to what it would have been had you used the updated study, shows a decrease in expenses.
It does, based
So if you, I'm sorry.
No, I'm sorry, I wanted to let you finish. Oh, okay.
Doesn't that indicate that, if you were to have done a study for PE, it's very likely, PE Maryland, that it would have also exhibited a decrease in the expense.
What it tells me is that for 2013, it would have. If we do another study in the future, that I guess I can't say that I'm going to have that same result. I'm sorry.
Okay, well, I'm just using what you've provided us, and it seems to at least tell me, at least I would interpret, that it's very likely that had a depreciation study been done for this case, it's possible. I mean, if the trend continues, that we would have also seen a decrease in that depreciation expense. And can I ask you, you did throw in Delmarva Power. When did they do their last depreciation study?
If I'm going off of memory, I'm trying to remember. I think this was from 2014.
Okay, so it's, again, not 25 years ago.
Right, correct.
And again, it looks like that indicates that it's at least less than the amount of depreciation expense that PE is proposing.
Yeah, it was about $1.5 million.
So again, there's, in all the most up-to-date examples you've provided, it appears that, in fact, we would see a decrease in those depreciation expenses had there been a depreciation study done for this rate case.
Yeah, based upon, say, a 2013 year, I think that this dictates that. I don't know in a future year.
Most recent.
Right.
Okay.
Okay.
All right. And the only, I was trying to understand why you brought up the PERPA and the Empower surcharges in relation to what we're discussing today. I mean, yes, it is a temporary, but this year maybe, offset. But is that what we're looking to do? Is just sort of fill a vacuum that might be an offset, or what is the point you're trying to make here?
The only point is that we're trying to struggle with the word. We have the benefit of, in conjunction with this rate increase proposed, there happens to be decreases, so it works generally to the customer's benefit in terms of overall impact, because it's better that this happened to happen whenever other rates were decreasing than when other rates were increasing.
Okay, but isn't it very likely, in fact, I mean, it's very, very likely that the PERPA charge will go up? Isn't there a special circumstance this year that decrease that rate? And isn't that likely to, I assume that the plant will run full year next year. Is that, we're talking about the Warrior Run?
Yeah, Warrior Run.
Yeah, so that there won't be this decrease in that charge, surcharge.
We're assuming the plant will run all year, and granted, the incident that happened in 2018 was an incident. What's going to happen in Warrior Run will be dependent upon market prices, and to the extent market prices increase, that makes the surcharge decrease.
But in any case, it's most likely that savings is going to evaporate very quickly, assuming Warrior Run operates all that, well, for 12 months next year.
Yeah,
Okay, so
certainly the surcharge will change next year. I just wouldn't know by the magnitude.
Okay, and then also with Empower, if the company doesn't hit its targets, it's likely to come back and say, hey, we need to actually increase our budgets. And so, again, there's a very good chance that those surcharges will go up. So both those offsets could just evaporate
They can.
quickly. Okay. All right, I guess those are my only questions. Thanks.
Madam Chairwoman, thank you. I get the back cleanup, it looks like. Mr. Valdez, thank you for your patience, and know that a lot of questions were deferred to you, so that's part of the reason why our collective discussions have been longer today. I'll try to be as brief as possible. I would ask you to do the same, and know that I am a big fan of answering questions directly.
Okay.
Okay? It's fair enough. I want to ask a follow-up question based on what the chairwoman asked you regarding, have you started a depreciation study in Maryland? And you said no.
We have not.
Right. But previously you described all this preliminary work that needs to be done before you can even commission a study with a consultant. Recall that?
That's correct.
So have you started that preliminary work?
No, not yet, because we're not sure what the Commission's ultimate decision would be in this proceeding.
Right. Well, we certainly can't say anything about that from the bench, but okay, we'll let it go there. Okay, so my line of question. First of all, I want to talk to you about general rate-making principles.
Okay.
You reference in both your direct and your rebuttal testimony the failure of the company to earn its authorized rate of return on equity, right?
Yes.
And so I want to talk to you about that a little bit. Isn't an ROE an opportunity to earn?
That's correct.
It's not a guarantee to earn.
I agree.
And there are many things that could prevent a regulated utility from earning its authorized rate of return. The most frequent ones that we hear as commissioners is regulatory lag or regulatory environment. I have my own opinions on those, and those aren't necessarily required to be stated here. But many other things can prevent a company. Management decisions, natural events, man-made events. A failure to file a base rate case for 25 years might even affect them, right? You could have an inflated ROE that doesn't meet the current market systems that's preventing you from earning that authorized rate of return. Wouldn't you agree with that?
Yeah, yes, I agree. And it wouldn't, the ROE being 11.9 or different numbers, say if you pick 10 or 10 and a half, it really doesn't matter because I agree that there is no guarantee of it. There's just the opportunity. And regardless of whatever that level is, whenever the ROE is around 5%, you're just nowhere near whatever the authorized level is.
I understand that, but because I'm getting you to the bench request that I had, so this is kind of a predicate discussion on that, because you cite in your testimony, I'm going to go to that, the fact that you haven't been earning, your company has earned, or Potomac Edison hasn't been earning its authorized rate of return as the reason to keep the overcollection of taxpayers' monies, right?
Yeah. We use that as a reason for that second regulatory liability.
Well, we'll transition there to my specific questions. If you could go to your direct testimony, page 19 of 46, and let me know when you're there.
Say page 46.
Direct 19 of 46.
Okay, I'm there.
Okay, so if you look at the top, line 1 through 3 asks, how should the commission handle the effect of the Tax Cut and Jobs Act between January 1st, 2018 and the effective date of the new rates in this proceeding? And I understand you filed this testimony, this direct testimony, August 24th, 2018. So my question is, because your response says the commission should not consider the amount deferred from January 1st through the date of this order, through the rate effective date, you subsequently modify that based on our subsequent orders, correct?
Yes.
But isn't it true that when you filed this base rate case, you wanted to keep all of that money?
Originally, we did, yes.
You wanted to keep every dime and nickel of it?
Yes.
Okay. I just wanted to establish that. So let's go back to where we are now. And we'll go to the exhibit that you cited, Exhibit 29, page 1 of 1, in your rebuttal testimony.
I'm there.
So the first boxed in number, 4,998,000, et cetera, to the right, under total deferred and carrying charge, those monies are flowing back to the ratepayers in Potomac Edison right now.
Yeah, they already have.
They have. They flowed back, one-time credit or...
Yes.
Okay. And the 3,130,000 is what's arguably due to them, that it's going to be overcollected from them between now and March 22nd.
Correct. That's the calculated value of that regulatory liability.
Right. So, wasn't First Energy the beneficiary of the Tax Cut and Jobs Act as well? Didn't their corporate rate go from 35 to 21%?
Oh, yeah, I would say the corporate rate would have affected all of the, yes.
Okay, so they're getting the benefit of that, but wouldn't the company's proposal to keep any portion of that flow directly to your shareholders, or in this case, your shareholder?
That would go the retention, because I'm talking about Potomac Edison now, if there's any dividends I don't know of, but that would be retention by the company.
Right, but since you acknowledge that the reason you want to keep the over-collected tax monies is your failure to earn your ROE, your authorized ROE, wouldn't keeping this money to fill that gap, a little bit, at least some, flow to your shareholder? Wouldn't it be a direct transfer? I'm going to be very blunt with this. Wouldn't it be a direct transfer from the ratepayer through PE to the shareholder?
I have to think through it, but
Where else would the money go?
I mean, it would be retained by PE and PE's owners, which are shareholders. Yes.
So it would be a transfer from the ratepayer who paid the taxes in good faith to the shareholders. In this case, it just happens to be First Energy. But you could have this discussion with any two parent subsidiary company relationships who propose the same thing. Right?
Yes.
All right. Thank you. You answered my questions of Mr. Sears about the depreciation study. I asked a question on the customer charge. Why, between the direct testimony of both you and Mr. Sears, and maybe Mr. Adams, I'm not sure about that one, did you propose an increase of $750 to $770 on a customer charge, or a proposed 50% increase to a proposed 54% increase between the time you submitted your direct and later submittals?
It was tied directly to the calculations from my exhibit REV 15, and the reason, the differences between the original August 24th REV 15 and the supplemental on October 28th was replacing those 3 months of forecast with 3 months of actual. It was a direct result of replacing, making the test year a fully actual test year rather than 9 months actual, 3 months forecast.
Are you aware recent decisions of the commission in rate cases have increased customer charges or customer type charges or fixed cost charges in the range of 2 to 3% and not in the range of 50 to 54%?
I'm sorry, I'm not aware. Bless you.
Okay. All right, fair enough. And you answered the question on the impact of PE from financial struggles of First Energy. I think you've answered all my questions, so I'm not going to belabor the point. And it'll be interesting to hear the rest of the witnesses and the rest of the parties on these matters.
Thank you.
So, thank you.
Mr. Valdez, thank you very much for your testimony and for being patient with us. We appreciate it very much.
Thank you.
Are there any other matters we need to consider this afternoon? No?
Nope.
Hearing none, we will recess for the evening and resume tomorrow at 10.
Thank you.